board. We left each other the other day talking about our or last weekend, I guess, talking about our CMAs and our BPOs, and that is one of your homework assignments. And remember, we discussed our BPAs and CMOs. We're just going to do a little recap here real quick. I don't want to go back through this everything. Kind of use BPO and CMA simultaneously. It used to be a difference back in the day, but they're pretty much done the same way. When we are performing a CMA or a BPO as part of our general brokerage duties, so in other words, when we're helping the seller determine list price, or when we're helping the buyer determine offer price, remember, I cannot charge a fee when it's part of my general brokerage duties. Nobody can charge a fee. That's just part of our job, you guys. So when the seller looks at you and says, what should we list my house for? Can't say, well, if you give me $150, I'll tell you, right? I cannot charge a fee when I'm doing it as part of my job. We can charge a fee when we're doing it for third parties. When I say we, I mean me and not you guys. Provisional brokers cannot charge a fee to do a CMA for a third party. So one example we had last weekend was the relocation company in Connecticut. They just wanted an idea of price. So they hired me to do a BPO for them. Chastity gave us a good example last weekend too of one of her coworkers that the divorce attorney, was that right? The divorce attorney wanted a couple CMAs done just so they could get an idea about the home. So we're not going to get this listing. We're not trying to get this listing. We're just helping somebody determine probable sales price. As a provisional broker, you cannot charge a fee. So I know a couple of you are on your last one, so you're close to where you can charge a fee. But if you're doing this for a fee, if you're doing this not for a fee, you want to make sure that you have your BIC with you, have some peers with you, go through these first couple ones with somebody else, put an extra set of eyes on it just to help you get the hang of it. Even after you get in your career and you get going, not all homes are easy to do CMAs for. If they haven't had a recently sold in the last year within a mile, for example, now you're starting to stretch a little bit. So remember your resources, remember get some training to get a better knowledge of that. The summary to wrap up this little section, we ended here on Sunday, so we're starting here today. The summary on this section is the Real Estate Commission and their expectations. When we're performing BPOs or CMAs, we always need to perform them in a competent manner, whether or not we're performing them for a fee or not. So even if you're doing it for a listing, guys, when in doubt, find out. Just don't throw numbers out there. You're harming your public. And then the last thing I have to say about this is I have Article 6 of your License Law and Commission Rule. I have the page numbers of the book here, but I would really rather you guys look at the commission's website. I'll show you again in just a second. And I'm not sure what that page number is, so don't pay attention to the page numbers. Article 6 of license law. And then there are commission rules as well. And then you have your sample and your manual. Those page numbers will count. Bottom line, make sure you always know what the current law and rule says. And when you're ever called on to do a BPO for a fee, I would go ahead and go to the commission's website and pull up the current law and rule. Fair enough?
Yes.
You got to follow those rules when you're doing this for a fee specifically. So real quick, while I'm thinking about it, because I know my little brain on a Saturday morning, if you go to the Real Estate Commission's website, the home page, and you go the whole way to the bottom, there's a link to license law and rule. And when you come in here, remember law is chapter 93A and then rule is 58. So anytime you're looking for the current, you always come here, always come to the website. And then you can scroll through and find chapter. wherever it is, find the chapter for CMAs and BPOs. And you should be able to find it in here more quickly than I can. And same thing with commission rule. So you'd always want to make sure you come here. Again, I was at the home page, license, law, and rule. There was an article, you know, we were just talking about due diligence, and there was an article, I think it was in February. Yeah, you guys make a note. There's a really good article in the February e-bulletin. Again, I'm still on the home page. So the February e-bulletin, there's a really good article addressing this hot market and buyers. What's happening is buyers are putting down $50,000 due diligence. They're having their home inspection done. The home inspection reveals that there's lots of electrical issues. The seller says, I'm not going to fix it. And the buyer says, that's not fair. I gave you $50,000. So the commission is reminding, guys, that's our job to explain that to the buyer. If they put down $5, if they put down $50,000, the seller's still not obligated to do any repairs. And that's our job to explain. So I thought this was a really good article that addressed that. So you guys want to make a note to check that out. Lots of good stuff on the commission's website. Any questions or comments about CMAs, BPOs? Again, one of your 2 homework assignments, both will be due by tomorrow, so we can talk about them tomorrow in class. So we had a floor plan, and then we have our CMA that's in Learn, Test, Pass. So if I haven't gotten your homework assignment yet, I need it by tomorrow. Questions on CMAs or BPOs? So we're still in the section of working with sellers. We spend quite a bit of time on working with sellers. And back to chapter 9 in our book, we had to branch away a bit to talk about CMAs or BPOs. But one of the big things when working with sellers is we need to advise them on a listing price. Sellers are going to ask this, you know, is a common question. When I sell my house, how much am I going to make? So we need to help them answer that question. We'll see that in just a second. But we need to help them determine that probable sales price. And that's why we do our CMA in a competent manner. If it's a property that you can't determine probable sales price easily, maybe it's a property that doesn't conform. Maybe it's the McMansion up on the hill, surrounded by cute little 1-story brick ranches, right? The property that doesn't conform. If it's a unique property, you may want to consider having a pre-appraisal done before you list. Have the appraiser put a price on it to help your sellers. Maybe you can get your sellers to go in on that cost with you. I would check with your firm in case that's a firm policy. But the current market conditions absolutely help us dictate how much we can get. Certain markets, we know we can get more for our sellers. So other markets, may get less. This is a hot market for sellers right now. But I still think it's important that we're pricing the property right. Have you guys noticing this? The buyers are the one driving those purchase prices up. The sellers are pricing them. Our CMAs line up. Our CMAs match probable sales price, but the buyers come in and start offering $30,000, $40,000, $50,000 over asking price. They're the ones driving it up. That's why we have closing prices more than listing prices. The homes that are on the market, the homes that have a lot of days on market are priced too high. And buyers see right through that, don't they? So I still think even in this crazy market, we need to price it right. That's just my opinion. But I think we still need to price it right so we can get the buyer in the front door. You know, when the seller prices it too high, my niece and her husband live 3 lots away from us as the crow flies, and they're right there. I helped them buy their house a year ago for $175,000. Last year, their neighbor that was catty corner to them, like their lot, the corner of their lots touch. Last year, they listed for $300,000. And buyers were going, how does this one close for $175,000 and this one right here go for 300. You know what? They had several price drops and they stayed on the market for about 90 days before they finally got a buyer in. Ultimately, to the seller, doesn't it come down to time versus money? I mean, if you want lots and lots of money, you may have to give up time. If you don't care about time, maybe you can get lots and lots of money. So again, conversations to have with your sellers. But I think in this market, buyers are seeing right through overpriced homes. And you know what? In other markets, I think buyers see right through overpriced homes. So even in crazy market conditions, it's still important that we sell it right. Take the seller's needs and desires into consideration. Again, time versus money. You know, what's more important to you? And maybe we have to look at the seller and just flat out ask them that. What's more important to you? Do you want to sell it really, really fast? Or do you want to make money off of it? So have conversations. Ultimately, they decide the list price. We provide the facts. They make the decision. I think we mentioned this last week. Do I have to take a listing? If the seller insists on listing it too high and I don't think in my heart of hearts that I can sell it for that, do I have to take that listing? No. So you may need to make the choice to walk away. I have thanked sellers for their time and walked away before just because I thought I couldn't get them what they wanted. We need to have conversation with the sellers about the sales price being enough. If a seller is underwater, they owe more than what the property's worth. So this is why we ask the hard questions very early in our relationship, like how much do you owe? What outstanding liens or mortgages do you have on the property? We need to make sure that they can afford to sell. If the seller's underwater, that means they need to bring money to the closing table. I would rather have this discussion up front before we sign the listing agreement than have it the day before settlement. I don't know about you guys, but if that's brand new information to the seller that they have to bring money to closing tomorrow, that could be challenging. And then with our needs, I mean, obviously, can the seller sell and still afford to pay us? You know, if they're underwater, the mortgage company is going to get paid before me and you guys. So if they're underwater, if they owe more than it's worth, we not only need to find out that they can bring money to settlement, but can they still afford to pay our commission? We're going to look at our listing agreement in just a second. And again, it helps us by listing out the seller's lenders, lien holders, and approximate balances. So it helps us have these conversations with sellers. We need to help the sellers understand or estimate their net. How much are they going to make when they sell it? We need to be able to help them calculate this. Now we're provided with a worksheet. We're getting ready to look at that in just a second. But the seller gets everything once everybody else has been paid, all their lien holders, all their closing expenses, me and you, the seller gets what's left. Do you think that's a common thing for a seller to look at us and say, how much am I going to make when I sell my house? I mean, that's right up there after how much commission do you charge, right? They want to know. Of course they want to know. Some sellers may look at you and say, if I can't make X amount, then I can't sell my house. If you can't put $40,000 in my pocket when this is said and done, then I can't afford to sell. Do you not have a material fact on your hand? If your seller says I have to make X amount or I can't sell, do you have? Yeah, absolutely. You have a material fact on your hand. Because remember, one of those specific material facts is things that are important to my client. So when the seller says, if you can't put 40 in my pocket, then I can't sell, then we have a duty to make sure that we can put $40,000 in their pocket. So I want to jump off PowerPoint for 1 second, get into Learn, Test, Pass. And if you look under the forms, we have Form 110 is a seller estimated net sheet. For those of you active, are you familiar with this form? Are you familiar with this one? This is a great worksheet for us to sit down with the sellers. We can do this when we're determining listing price. And you see, we got 3 different price points that we can look at. This is good too when you have multiple offers. You have multiple offers with 3 different prices, right? So you can kind of break down so the seller can see their bottom line as well. So we have the sales price. We can look at 3 different scenarios per worksheet. as many worksheets as we need. And then we, get the seller's mortgages or liens, help them determine what their approximate balances are, what their closing costs are going to be, attorney's fees, document preparation, brokerage fees, if they're paying for a home warranty. Here's their prorated taxes, prorated HOA, all the expenses, their revenue stamps, also known as excise tax. That's an old school term to call excise tax revenue stamps. Same thing. Any pre-marketing expenses. Are they going to have an appraisal done to help us determine probable sales price? Are they going to have a pre-home inspection done? All that has to take into consideration. And then when we add it up from, take the top number minus everything in between, then we can learn what the estimated net proceeds to or from the seller is. What I like about this form is it has a place for the seller to sign, for the seller to acknowledge that we presented it to them. Absolutely, Chastity. I think this helps sellers understand both when you're helping to list it, because sellers don't know about paying excise tax, and they know they got to pay us, but they don't know about a lot of these other fees involved when it comes to selling. It should be in zip forms. It's form 110, if that helps you find it. Sometimes if you know the number, it makes it easier to find. So it's standard form 110. And like I said, I know there's agents in my firm that use this in a multiple offer situation. So they can say, this is what offer number 1, this is what this would put in your pocket. Offer number 2, this is what this would put in your pocket. Kind of give the seller, help the seller better understand which one to offer. I'll also share this with you guys. My full firm, just within the last 5-6 months, has determined this is a required form. In other words, our agents don't get paid if this isn't filled out. Seller sign it. I took a class with NCAR a month ago, and the instructor from NCAR said, if the real estate commission ever needs to see your transaction file, this is a form that they're looking for, because this shows that we had the discussion with our sellers about their money, about their net. Comments on this one, questions? It's a good worksheet. Okay. The other thing we can help sellers do is determine their net profit. Usually we see this more when our seller's an investor. This is not math you need to know for your test, but I do think if you plan on being an investor or plan on working with an investor, this is a good information for the seller to help them determine net profit. So there's net income and there's net profit. To find the seller's net profit, it's actually a 3-piece formula. So the first thing we want to do is help the seller find their adjusted sales price. The adjusted sales price looks at the sales price that they plan to sell the property at now. What are they going to sell the property at today? And we're going to deduct the seller's closing expenses. So attorney's fees, brokerage fees, all those closing expenses. And that gives the seller their adjusted sales price. The second piece of this formula is to help the seller determine their adjusted cost. The adjusted cost looks at the purchase price. The purchase price is what they paid for it back in the day. So whenever they purchased this property, what did they pay for it? And then we're going to add any closing expenses. If the seller made capital improvements during the time that they owned it, then we would add that here as well. Let's all understand, plus capital improvements. Let's all understand that a capital improvement, it's something that adds value. Painting a room does not add value. Finishing an unfinished basement adds value. If you can add square footage, you can add value. So if they had any capital improvements, if they put money into it when they purchased it. So the adjusted cost looks at back in the day when we bought it and what we did to it while we owned it. Adjusted sales price looks at what we sold it for. So to help the seller determine their net profit, we look at the difference between the two. We look at the adjusted sales price minus their adjusted costs. And that helps us determine, hopefully, the seller's profit. If that number is a negative, then we could be, the seller could be looking at a loss. Again, no math on this on your exam, but possibly helpful when you're working with sellers one day. Questions? So what we're going to do now, we're going to go in the section 2 material of Learn, Test, Pass, and we're going to spend some time looking at our exclusive right to sell listing agreement. This is the most commonly used listing agreement that we use. We do have other listing agreements. Your firm may have their own listing agreement. Your builder, for example, if you're working with a builder, they may have a listing agreement. Guys, it's so important that we understand that I am not only limited to use the standard forms provided to me by the North Carolina Association of Realtors. I'm free to use any form as long as it was drafted by an attorney. So if you've ever seen a form drafted by an attorney that another company uses, somewhere on that form it should say drafted by Wyatt Early Harrison Wheeler, or created by, help identify. If it doesn't say that, I would ask some questions, because in order for us to use it, it has to be attorney drafted. So if the form doesn't specify, you should have a little flag that goes up to ask some questions to make sure that it is an attorney drafted. Again, this is the one we're going to go through because this is the most common one. It's also important that we understand that our exclusive right to sell listing agreement comes with guidelines for completing. So when in doubt, find out. If you don't know what goes into a blank, or if you don't understand what should go into a blank, go to the guidelines, go to your real estate manual. You guys all have a copy of this book for this class, I hope, or the digital version, and you have good information in there as well. You have your broker in charge. Don't just put something in a blank for the sake of putting something in a blank. You got to stop and ask yourself how this would stand up in a court of law if it ever got that far. So exclusive right to sell is entered into between the seller and the firm. Remember, our agency agreements are a relationship between the client and the firm, not the individual agent. So the firm creates the relationship with the client. The firm allows you to work with their seller. We go on to explain that the individual agent who signs this agreement is doing it on behalf of the firm. They're the ones that are primarily responsible for making sure that the firm's duties are fulfilled. However, it's understood and agreed that other agents of the firm may assist. They may also fulfill such duties if deemed appropriate by the firm. So have you ever been to an open house and somebody's there that's not the listing agent? They're probably, hopefully, I'm assuming, another agent with the firm. We owe all that duties to the seller to help them sell, because they hired the firm to help them sell. If you leave your firm, can you take your listing with you? No. The answer is it depends, doesn't it? It's up to the firm. If the firm releases it, then you can take it. But if you leave your firm and go to another firm, your listing is not a guarantee to go with you. Check your firm's policy. I know it's so funny to say this, but before you guys affiliate with a firm, read your independent contractor agreement and see what happens if you leave, when you leave. I know you're excited. You're just now getting ready to sign up. Julie, why would I ever think about leaving? This is my dream firm. But Before you sign, make sure you know what happens when you leave. We have a blue note. Notes and warnings, blue notes and red warnings were added to our documents, I don't know, 5 years ago, 8 years ago, something like that, to help draw our attention to various things. So this first blue note says that the property was most recently owned by a person who is now deceased. The tax listing or the last recorded deed of the property may not be accurately identified. In such case, the deceased owner's will or the applicable law of the deceased owner's will without a will determine the correct party. We are advised to contact an attorney. Make sure you're dealing with the estate attorney. Make sure you know you're dealing with the appropriate party. If the owner of the property is a corporation, LLC, or a trust entity, an entity should be named as the seller. So if it's a company or an LLC, we don't have a person. We have a business that we put in as the seller's name. There is one person that will be allowed to sign on behalf of the company or the LLC. I would just make sure that that is the person allowed to sign on their behalf. And then we're also told that a non-owner spouse should be named as the seller because they will be required in most cases to sign the deed. So if somebody purchases property and then gets married, their spouse isn't going to sign up on the deed. Isn't going to show up on the deed that you pull. So somebody buys a home and then gets married, the spouse's name isn't going to be on the deed. However, North Carolina is a spousal state, which means it takes one to buy and two to sell. And there are only two answers to the question, are you married? If you're separated, you're still married. If you're engaged, you're not married, right? So the only two, it's not complicated. It doesn't depend. Are you married? Yes or no? And they will be required to sign the deed to convey. And once again, we're instructed to consult with an attorney. So use these blue boxes. We're getting ready to see a red warning in just a second. Use this information to help you make sure you're proceeding properly. I don't want to hear of any of you getting in a situation where you made it the whole way to closing and find out your sellers were in breach because they'd had a spouse that wasn't going to sign. Ask the hard questions up front. Will you guys promise me that? Ask the hard questions up front so you don't get to the end. Because you know what you get if you get to the end and they breach? Yeah, that's right. That's right. That'd be a bad day. In consideration of the firm's services and efforts to find a buyer, firm is hereby granted the exclusive right to sell the property on the terms and conditions set forth in this agreement. Seller represents that as of the effective date, the seller is not or will not be a party listing agreement with another real estate firm regarding this property. So they can reach out to you while they have a listing agreement, an active listing agreement. We can't proceed until that expires or terminates. Okay, so it can only be in one. Remember, this is an exclusive relationship. How many firms is the seller allowed to date? The seller can just date just one. It's an exclusive relationship. If you're dating somebody exclusively, you should only be dating one person. Seller also represents that they've received a copy of Working with Real Estate Agent Disclosure and they've reviewed it with the firm. The first provision is the term of our agreement. The term shall begin on the effective date and end at 11:59 p.m. on its expiration date. The effective date could be the date that this agreement has been signed by both parties. So if you plan to get your listing agreement signed and get it in MLS on the same day, then you would check this first box. You get it signed and you get it in MLS, you market the property on the same day, then we would check the effective date. The truth is, I don't think that happens that often. We get the listing agreement signed and then we make arrangements to show up for picture day, come back and take measurements, right? If you have somebody doing your photography and your measurements, you need to get them scheduled to go out. I'm not saying it can't happen on the same day, but I think more likely what we see is the delay in marketing. which we'll see in just a minute on this form. So just make sure you're paying attention to what that effective date is, what's that saying.
So would you not mark anything there, Julie, if you're going to
That's
mark?
correct. I will leave it blank here, and then we're going to address it again later in this form. Thank you, Donna. Yeah, we'll address it again later. The other option that we have here is if the property is currently listed for sale with another firm, seller represents that the current listing agreement expires on this date. So the effective date is this agreement shall affect immediately after the expiration of the current listing. So in this case, the effective date is not when we sign it. The effective date is when the current listing expires. Again, they have reached out to you. We cannot solicit somebody else's active. So they've called you. They said, I'm tired of my listing agent. We expire on Friday. Can you help me? Can you go live on Saturday? And document the heck out of the fact that they reached out to you first, just in case. Article 6 of the Code of Ethics just reminds us that we cannot solicit somebody else's active listing, active client. And then we have an expiration date. This agreement shall terminate on 11:59 p.m. on, and we need to put it in an actual date here. So whatever day you and your seller agree to. All markets are different. You know, in this market, you may not need as long of a listing agreement because houses are flying off the shelf, but I promise you, we're not always going to be in this market. One day we're going to get back to this idea of normal, whatever that means. And when we get back to that idea, you may have a listing agreement for 4 months, 6 months, 8 months. It just depends. Then we need to identify the property, the subject property, the property you're getting ready to list. So here's our street address, city, county, zip. This is a North Carolina form for a North Carolina property, so they took care of that for us. We don't have to worry about putting in the state. And then we have a place for the legal description. Complete all applicable. Guys, never leave a blank blank. So if something's not applicable, put N-A for not applicable. This is the information that you get from your tax records. This is the information you get from your GIS search. Again, when you're gathering this information, a firm will help you. Your BIC, your firm should help you know where to get this information so we can properly fill out the forms. Our blue note here says the following paragraphs 3 and 4, we're getting ready to see, are part of the offer to purchase and contract. A form which is commonly used to put real estate under contract in North Carolina. To minimize the potential for disputes with a buyer, it is highly recommended that the seller and the agent discuss in detail and describe in writing what items seller is willing to convey as part of the sale, what items seller would like to exclude from the sale, and what items are located on the property that the seller may not own. So we need to have these conversations about fixtures and personal properties and leased but not owned stuff. We need to know what the seller's intentions are going to do, what the seller plans to do, so we can properly advertise and market and let the buyer know. If a fixture is going to go, we need to let the buyer know. We have that duty. So the third provision is our fixtures. Here's our first red warning. Again, these are here for a reason, so don't just gloss over these. The party should not assume, I hate the word assume anyway, so never assume anything, but the party should not assume that an item will or will not be included in the sale based on an oral or written statement or understanding that is not part of a sales contract. Buyer and seller should be specific when negotiating what items will be included or excluded from the sale. If you haven't seen me in 302 yet, when you go to take 302, we're going to talk about something called the parole evidence rule. And the parole evidence rule says the final written word will prevail. So if you advertise the refrigerator is going to stay, you put it in your listings, the buyer says, is the fridge going to stay? And you say, yeah, it's going to stay. But the fridge never makes it in the offer to purchase and contract. Does the seller have to leave the fridge? No, because the final written word prevails. So your marketing and advertising means nothing if it doesn't make it to the final offer to purchase and contract. And that's our duty as the listing agent and the buyer's agent to make sure fixtures and personal properties are there. Fixtures are included in the purchase price. All existing fixtures are included in the sale as part of the purchase price, free of liens, unless excluded below. Buyer and seller agree that the following items, if present on the property on the date of the offer, shall be included in the sale as part of the purchase price, free of liens. All items below include both traditional and smart versions and any exclusively dedicated related equipment and or remote control devices. Tell your sellers, make sure your sellers leave the garage door openers. Those things are usually on the visor of the car, and they're easy to forget about. The garage door doesn't open without the garage door, doesn't work without the garage door opener, does it? So make sure your sellers know to leave that before they're halfway across the country, moving to wherever it is that they're going, right? So just make sure you have that conversation. And then we get a list of fixtures. This exact same list of fixtures shows up in our offer to purchase and contract. So this is our opportunity to have a conversation with the seller now. Let's look at this list and see if you're going to take anything. And the seller may say, okay, we'll read it tonight before we go to bed. You know what? I'm a really patient person, except for when I see brake lights on the highway. Other than that, I'm a pretty patient person. And I can sit here for 3 minutes while you look over this list. Because if you plan to take your, I don't care, pick something. If you plan to take your mailbox, maybe this was a wedding gift and it has value to you. It means something to you. You can take your mailbox, but we need to talk now about what you're going to do, what you're going to do to replace it. When do you plan to replace it? We need to have this conversation. Ideally, in a perfect world, sellers will remove the fixtures before you ever show up for picture day, before a buyer ever sees the property. Do we live in a perfect world? No. You may get some sellers that say, every single piece of mail that we've received since we've been married has gone into this mailbox. And I'm not going to jinx my marriage by taking this mailbox down early. So I'm going to keep this mailbox up until the day we move out. And that's when I replace my mailbox. And you say, all right, people get attached to stranger things, don't they? And you say, all right, you love your mailbox. I hear you. It now becomes my job as the listing agent to let every single buyer know that when they buy that house, they're going to have a different mailbox. Okay, the seller will replace it. Everybody good on that? We've got to talk to the sellers about this up front. And if the seller refuses to take it down, we have a duty to let all potential buyers know that when they move in, that mailbox will not be there. And y'all know how petty buyers can be, right? Oh, buy this house, it would come with that mailbox. You know, that's when you might hear that. We can find you another mailbox that you'll love just as much. Unpairing or deleting data from devices prior to closing. Seller shall unpair any devices that will convey from personal property, hubs, intelligent virtual assistants, mobile devices, vehicles, etc., with which they are paired. Delete personal data from any devices that will convey and restore all devices to factory default settings. Seller's obligation under this paragraph shall survive closing, which means if the seller forgets to do it, they still have a duty to do it even after closing. This verbiage might get reworded a little bit. Just to let you know, we do have new forms come in July of 2022. So just be on the lookout for that. Your firm will help you notify the changes. When I took that NCAR class a couple months ago, she addressed this, and they may have to change the verbiage to make sure that the seller understands that it's their responsibility to unpair. She said there had been complaints. The seller got angry at the deal and they didn't unpair. So after closing, they would like drive up and down the street in front of the house and mess with, you know, turn the lights on and off and, you know, whatever they had the power to do on their phone because they didn't unpair, they didn't delete. Isn't that funny? So the buyers are sitting in the new homes and the lights are flickering and the Ring doorbell's going off and they're going, what's going on? And the sellers are driving by messing with them. So we might see some different verbiage because of that with the form changes. Aren't people fun? But, but again, make sure your sellers understand that they have that duty to unpair, reset to factory settings. Our blue note says any fixture, other item described in subparagraph A and B that will not be part of the sale should be identified in paragraphs D and E below. And then we have a place, if anything's leased or not owned, the seller has it in their possession, but they don't own it. That is not going to convey. The seller can only convey what is theirs. So they need to identify anything that's not theirs. And then if they're going to take any fixtures, other items that do not convey, either anything on that list or anything that could be considered a fixture, if they plan to take it, this is why we have this conversation in the listing agreement. And then we also see this in our contract as well. The seller is responsible for repairing any damage caused by the removal of taking down any property. Questions about our fixtures? Every once in a while in our forms updates, we get a new fixture added or new verbiage added. I've always heard, I don't know if it's true or not, but I've always heard that these are the results of a lawsuit, of a court case. Buyer moves in after settlement, they think something should be there and it's not, so they sue the seller, so then they add to our form. So the most recent addition was last year, or maybe the year before, when they added thermostats. And I'm thinking this is referring more to smart thermostats. I hope there isn't a seller somewhere that ripped their thermostat out the wall, off the wall on their way out the door, but I'm not putting them past it either. So just be prepared for additions to fixtures to come, because we do add to this list regularly.
Well, if the thermostat's been there since they got married, they might want to take it.
And that's fine. We just got to exclude it, right? This thermostat has sentimental value to me, and people get hooked. My Sunday morning guilty pleasure is hoarders. And let me tell y'all what, people get hooked on their stuff. Woo, it's crazy.
Julie, I actually had some buyers buy a house, and when we did the final walkthrough, the thermostat, it was like a smart thermostat system. And they had
Really?
taken it all down and left a hole on the wall. And we had to get it resolved before closing.
Before they closed. So
Mhm.
there's a reason why that's there, you know? So good for you for helping your buyers with that. I'm sure they were a little disappointed in the final walkthrough to walk in the front door and see a big hole in the wall. Be like, well, how are we supposed to adjust the heat? So it happens, guys. People get petty. I hate to say it, but when we get to the end of the transaction, people get petty. They felt like they deserve something else, right? So if it comes down to a thermostat, don't let a thermostat kill your deal the day of closing, right? Have this discussion up front. Other questions or comments about fixtures? We'll talk about personal property when we come back from break. So with that being said, it's break time. So let's take 10. I got 10 o'clock on the dot. So let's come back at 10:10 and we'll talk about personal property. By the way, let me go back for 1 second, just make sure we're good. When we're putting the name of the sellers in, we need to put all the names of the sellers that have to sign to convey the deed and their spouses. So, like, for example, I was going after for sale by owner once, and it was an estate. It was grandma left the home to like the 4 grandkids, and all 4 grandkids were married. So had I gotten that listing, I didn't get that listing, but had I gotten that listing, I would have had to put in all 8 people in this. You want to make sure everybody that has to sign the deed is on board from day one. Don't get to closing to have a spouse say, I'm not signing that, right? If they're not signing the listing agreement, then you should have a flag to go up to ask some questions. Yeah, Plumber.
So do we do an addendum with the names, or how do we squeeze all 8 names?
We can do an extra piece of paper. I
Okay.
also have, and remind me, I'll look at it, just see if we have it in just a second, but we have an additional signatures addendum.
Okay.
So this listing agreement allows me for 2 people to sign. So if you have more than 2, we can do an additional signatures addendum to get, and I think there's 8 more signatures there, right? So now you got 10 people signing. If you got more than 10, you keep adding that signatures addendum until you get. But you may have to say, like, for complete list of names, see attached, if you got more people than can fit on this little line. But the important thing is to get their signature. Good question. Thank you. So we talked about fixtures. The opposite of fixtures are personal property. Fixtures are meant to stay. Personal property is meant to go. So if they're going to do the opposite of their intent, then we need to discuss it. We need to discuss it not only in our listing agreement, but also make sure that it shows up in our offer to purchase and contract. Because remember, the final written word will prevail. It does not matter if your seller says, I'll leave the fridge. Yeah, I got you back. Seller says, it doesn't matter if the seller says I'm going to leave the fridge. If the fridge doesn't show up in the contract, then the seller's not obligated to leave the fridge. I also think, guys need to be specific when identifying personal property. Don't just say fridge, especially in the offer to purchase and contract, but make sure you're specific here, especially be specific in the contract. There have been stories, I don't know if they're true or not, but I have heard stories, many over the years, where the buyer asks for the fridge in the offer to purchase and contract, just fridge, I want the refrigerator. Buyer goes to the home after settlement, and in the kitchen is a 2-shelf dorm room fridge. Did the seller do what they were contractually obligated to do? Yeah, they left a fridge. Is your buyer happy? No, not at all. So be specific. Whirlpool, 2-door, stainless steel. If you can see the model number, these things are tethered to us anyway, right? Why not snap a few pictures, make sure that we all see. Now the pictures we can't attach to the contract, right? But at least we have our documentation specifically about which fridge we're talking about. So be clear. Also, you guys with sellers, they may want to leave the fridge, but what if the buyer doesn't want the fridge? Just because the seller intends to leave it doesn't mean that the buyer wants it. It's still personal property. So if the buyer doesn't want it, the seller needs to make arrangements to get it out. Okay, I had that with the listing. The seller was willing to leave the fridge. I said, great. Offer came in, no fridge. I called the buyer's agent. I said, hey, do you guys want your fridge? And she said, nope, they have their own. Okay, just wanted to be sure. I told my seller, I think you put it on Craigslist and you made $40 off of it or something. You know what I'm saying? So he's got to make arrangements. They got arrangements to get it out because it is still personal property. Our blue note says any personal property that will be part of the sale should be identified in this paragraph. Buyers advised to consult with their lender to assure that personal property listed above can be included in this contract. Guys, remember, we're real estate agents. We're not personal property agents. Remember, the lender is given a home loan. They're not given a loan for stuff. So if the lender starts seeing this list grow in the offer to purchase and contract, dining room, suite, bedroom furniture, the lender may start asking, what am I giving this loan for? Am I gonna give it for a home, or am I giving it 30-year financing for the lawnmower, right? So anything other than, I think the refrigerator is pretty typical. After that is the washer and dryer. But as that list starts to grow, check with the lender and make sure it's allowed. Comments on that? Questions? Listing agreement addresses a home warranty. Seller agrees or does not agree to obtain and pay for at settlement a 1-year home warranty for the property not to exceed X amount. Note that says not to exceed. So you're not putting the amount in here that the seller's willing to pay. You're saying they're not going to pay anything more than this, right? That's as high as they're going. If the seller agrees to obtain and pay for a home warranty, firm hereby discloses that a fee of X amount will be offered to the firm. Check with your firm policy on this by the person or entity through which the home warranty is obtained. So you may be able to collect a fee. The firm may be able to collect a fee, but that's up to your firm's policy. Home warranty, RESPA tells us we can't get settlement service providers. Home warranty companies have found a loophole. I think the best that I understand it, y'all get with your firm to see what your firm's policy says. But the best I understand it is a home warranty company isn't a settlement service provider. In other words, their service kicks in after settlement. And I think that's the loophole that they figured out. But again, check with your firm. They may have a policy on what put, if anything, in this blank. Then we have the listing price.
I got a question on the home
Yes.
warranty. What if there's an existing home warranty and the sellers wish to, it's paid for, and let's say they're 5 months into it and the sellers wish for that? Because that's what, that's part of the home warranty company sales pitch. If you sell the house, you'll be able to transfer this.
So they've already obtained it. So we can just say that they agree to obtain, and then make sure you let the buyer, let's put it in agent only or something in MLS.
Mhm.
Sellers have existing home warranty with ABC company that's, good for 7 more months, right? So you'd want to communicate that to buyers agents and buyers and let them know. And you're right. Some warranty companies say this, the seller puts a warranty on the home. It'll cover the buyer for the first year, but it'll also cover the seller during the time that they have it on the market. And that's a hook that the home warranty companies can use. Again, we're not seeing a lot of home warranties in this market. We're seeing some, but not a lot. Sellers aren't paying for it if they don't have to right now, because they don't have to. So just know that we're going to start seeing more and more of that as this market normalizes, whatever that means. Listing price, guys, I cannot ask the seller to sign this listing agreement until we have filled in this field. We cannot say, just sign this and then we'll figure this out later. We're not supposed to have the seller sign this thing if it's not complete anyway. But this is the field that is absolutely not allowed. We have got to have a price in here before we ask the sellers to sign anything. Is everybody good with that? Can I get some thumbs up acknowledging that? Okay, cannot have the seller sign if we don't have the price. And then we need to identify the following terms that would be acceptable to the seller. Some sellers don't want to deal with a lender. Some sellers may say cash only. Not all homes can get FHA or VA approval. If there's a lot of work that needs to be done, we may not be able to offer this type of financing. Is it USDA? Go to USDA's website and look at the map. If it's a rural area, and see if that qualifies. Is the seller willing to do a loan assumption, seller financing? So this is where we're identifying, and we list these types of financing in MLS. The financing that the seller determines that the seller will consider, that the seller will accept. So if you're working with an FHA buyer and they want to see a listing, you need to look in MLS to make sure the seller is willing to accept an offer of an FHA buyer. Why waste your time showing the property just to find out? So take a second and look at MLS and see if the seller is willing to work with that. Then we talk about our money, firm's compensation. Seller agrees to pay the firm a total fee of percentage of the gross sales price of the property or a flat fee, X amount, which shall include the amount of any compensation paid by the firm as set forth in paragraph 8 below to any other real estate firm. So let's shorten that down. Seller agrees to pay the firm a total fee of, which includes any compensation paid to any other real estate firm. The seller pays the listing firm shares their commission with whomever brings the buyer. So what we're looking for in this field is the total commission, not your split, the total that the listing firm expects to receive. We'll see in just a minute how they're going to share it with the other firms. Okay, so whatever your firm's policy is on commission. We go on to talk about when we've earned our fee. Is everybody good? When we earn our fee and when we actually get paid are two different things before we get into this. We earn our fee, but we're not paid until it closes. So when do we earn our fee? Our fee is deemed earned under the following circumstances. So when we bring a ready, willing, and able buyer, a cooperating real estate firm, the seller, or anyone else during the term of this agreement at the price and term set forth at any price and term acceptable to the seller. So whenever a buyer makes an offer, no matter where they're coming from, if they're coming by the firm, a cooperating firm, or the seller themselves, or anybody else, in terms acceptable to the seller, we've earned our fee. Does the seller have to accept any offer? Dream offer, 100,000 over asking price, cash, closing in a week. Does the seller have to accept that? No. Again, have conversations with your sellers up front. Make sure you understand what they're willing to accept. Make sure you understand what terms will be acceptable to the seller. We may also earn our fee if the property is sold, optioned, exchanged, conveyed, or transferred, or the seller agrees during the term to sell, option, exchange, or transfer at any price and any term upon whatsoever. I'm sorry, Plummer, did you have a question?
I was going to ask, so really the that's what I'm looking for. The qualifier there is the acceptance.
That's right.
So
That's right.
ready,
That's
willing, and
that.
able does not mean you've earned it. Is when they've accepted it.
That's right.
Okay.
Terms acceptable to the seller. That's right.
Okay. Thank you.
So we basically, if we can sum this up, we earn our commission when we go under contract, pretty much, right? We don't get paid until it closes. That's the conversation I just had with pre-licensing this week. We don't get paid every time we talk with a seller or buyer, do we? They don't all go to closing, so we don't get paid. We'll see how many people come back to pre-licensing next week. That's usually where I start losing people. That's the hard truth about real estate though, right? If it doesn't close, we don't get paid. The other time we've considered earned our fee, if the circumstances set out above have not occurred and within X amount of days after the expiration date, the seller either directly or indirectly sells, option, exchange, conveys, the property upon any terms to any person with whom the seller firm communicated regarding the property during this term, provided the names of such persons are delivered to the seller within 15 days after the expiration date. We'll break this down in a second. However, seller shall not be obligated to pay the fee if a listing agreement is entered between seller and another broker and the property is subsequently sold. So what's all this mean? We have in our listing agreement something called a protection period. The protection period protects us. The protection period protects our commission. And what this paragraph says is if that a seller accepts an offer within X amount of days after the expiration date, is it 2 days? Is it 35 days? Check with your firm. They may have a policy, and that number of days is negotiable. So within X amount of days after the expiration date, if the property sells, we could still be entitled to commission. If I expire tonight, let's say our listing agreement is up on April 9th. That means at 11:59 tonight, me and the seller are done, right? We've expired, we've cut ties, we've gone our separate ways. If somebody makes an offer to the seller tomorrow, couldn't that stand to reason that they learned about that property through my marketing and my advertising? Because I was on the market until 11:59 tonight. You guys with me? So if it expires and another buyer comes forward and makes an offer, we still could be entitled to commission. There are some caveats with this. We have to provide the names of the buyers to the seller within 15 days, right? So it's not just any buyer that makes an offer, it's specifically this buyer. So you know you have an interested buyer out there. The public and other firms in MLS don't see your expiration date. That's an internal thing only. So the public has no way of knowing that this thing expires today, right? Agents and other firms don't know that this thing is going to expire today. Agents in your firm don't know. That's pretty much a you and your BIC. So if they come forward, you say, I know for a fact that Mr. and Mrs. Smith are interested. We're expiring today. If Mr. and Mrs. Smith come forward tomorrow and make an offer, I could still get commission, but I got to provide the sellers a name. Is everybody good with that first caveat? It's not just any buyer. It's specifically interested buyer. And then the second piece of this is if I expire today and my seller lists with a new firm tomorrow, I'm out because the new firm now has the current listing agreement with the seller. So they're going to get paid. So if they enter into an agreement with another firm, question came in, what's a reasonable time? You know, all firms have a different policy. Some may do longer than others. There's not, unfortunately, it's one of those things, there's not an answer to that. So check with your firm. They may have a policy about what they want you to put in here, but it's blank, which means it's negotiable. So if you show up saying 30 days, your seller might say, let's just do 14, right? So that's completely negotiable. Again, protection period is protecting our commission. Yeah.
So clarification. So the listing expires today.
Mhm.
Tomorrow, a buyer that I am aware of wants to make the purchase.
Mhm.
Let's say the protection period is 10 days.
Okay.
On day 6, a buyer that I'm aware of wants to make the purchase, and I need to present that name to the. Okay, what if I don't present the name? I'm not aware of it. The buyer contacts directly or whatever, is doing they're doing an unrepresented buyer thing. They contact the seller,
Directly.
right? But it's based off of my advertising. It's my advertising that saw the seller is not under a contract with a new listing agent yet. It's based off of my advertising in that protection window. So what happens then?
Either you have an honest seller that calls you and says, hey, I got an offer,
Mhm.
or somehow you got to find out on your own. And that is an excellent point, Plumber, because if you don't have an honest seller that calls you and tells you, you have to find out on your own.
Right.
But remember, because you're providing names, right? So you're
Mhm.
not just handing them a piece of paper with a name on it.
Right.
Hopefully you're explaining why you're handing them those names,
Okay.
right? So hopefully you can rely on, and the sellers may say, whatever, I'm listing with a new firm tomorrow, so it doesn't matter, you're out. The sellers may say, okay, Plumber, we'll call you if an offer comes in within 10 days. But that's absolutely where it can get tricky, right? Because we got to rely on the sellers. So have the conversation with them, guys. And I understand it's written out in our listing agreement, but I'm here to tell you, our buyers and sellers don't read this stuff. They don't expect them to go through this clause and know what they're supposed to do in this scenario if it expires. If it's expiring soon, you're probably having a conversation with your seller, like, hey, we're expiring in a week. What do you guys want to do? Do you want to extend it? Do you want to terminate? You know what I'm saying? So as you're getting closer and closer to this expiration date, hopefully you're having a conversation with your sellers anyway. And then again, when you hand them or email them or deliver the piece of paper to the seller that says Mr. and Mrs. Smith are interested, you're reminding them why you're delivering that name. Other comments on that? It's better than nothing for us, isn't it? It's better than nothing. Let's see, fee due and payable. So we talked about when we've earned our fee. Now let's talk about when it's due and payable. That's the difference. Once earned is set forth above, the fee will be due and payable at the earlier of distributions of proceeds from the sale or the seller's failure to sell. So if we present 20 offers and the seller doesn't accept any of them, we may still be entitled to a commission. Now, we may have to get the courts involved, right? And remember, it's not the individual that can sue the seller because the individual doesn't have the relationship with the seller. So the firm may choose to sue the seller. Let's see, including but not limited to seller's refusal to sign an offer for the property at a price and terms stated herein. So that example we just gave, when the dream offer comes in, if the seller says no, we may be able to get the courts involved to help get our commission because we delivered, right? We did our job and brought them that acceptable offer. I can't make them sign it though. The seller's default on the executed sales contract, we could still get paid. So in other words, if we go under contract and then the seller finds out they cannot convey clear marketable title, hopefully we did our jobs up front and asked the hard questions before we got here. Or the seller's agreement with a buyer to unreasonably modify or cancel an executed sales contract for the property, or seller's breach. So we may still be able to get paid, but again, that goes back to firm policy. And guys, firms don't want to be known. They don't want the reputation of suing a seller or buyer at the drop of a hat. It doesn't take long for that word to get out. Sellers aren't going to call you going forward if you're in the habit of suing them for not closing. You guys with me? So it's up to your firm's policy. I just don't want you guys to have this expectation that they terminate and you can still get paid. I'd rather y'all not spend that money until that check is in your hand or direct deposit it into your bank. But that's up to the firm's policy.
At what point in this whole process, Julie, does a title company get involved?
Once we go under contract.
Okay, the title company, then they do the title search, make sure it's not encumbered.
Our closing attorney does our title search in North Carolina. Yep. If there's any questions about the title when you're listing it, encourage the seller to hire an attorney and get it addressed now, right? Because we know if there's issues, they know they're going to come up when we go under contract anyway. So if there's any issues or concerns, encourage the seller to hire an attorney and start getting the stuff straightened out now. Let's see. Transfer of interest if the seller is a partner or corporation. Applicable law does not prohibit the payment of a fee or commission in connection with the sale. The fee shall be calculated on fair market value of the property rather than the gross sales price. So again, if you're dealing with a business, just kind of put that off to the side unless you're dealing with a business. Additional compensation, if we're going to receive an incentive or a bonus or rebate or other valuable consideration, is offered to the firm from any party or person in connection with the sale. So anybody other than our seller principal, if somebody else is going to pay us, then we have to disclose that to our seller. So maybe for some reason in this market, it wouldn't surprise me if a buyer's agent was offering to compensate you for getting them to accept your offer or something. I don't know. I just made that up. But if we're going to make more money from anybody other than our seller, then we have to disclose that to our principal in a timely disclosure. Timely disclosure does not mean by the by when you're sitting at the closing table. Timely disclosure means before you, as soon as you find out about it. Let the seller take that into consideration. We have a note here that we have a form if we are receiving additional compensation. So NCAR provides us a form to use. Thank you, NCAR. And then the attorney fees and costs. If the firm is the prevailing party in any legal proceedings brought by the firm against seller to recover any or all fees, firm shall be entitled to recover from settlement from reasonable attorney fees and court costs. So if the firm sues the seller for commission and the firm wins, not only will the seller pay commission and their court fees, but they also get to pay the court fees of the firm too. All that's spelled out in the listing agreement. And again, I'm stressing the word if the firm sues the seller for commission. And then we talk about how we're going to compensate other firms. Remember, the seller pays the listing firm shares their commission with whomever's bringing the buyer. And we need to make sure that the seller's on board with how we're going to share our commission. Not all commissions are 50-50 split. And if your firm's policy is not to do a 50-50 split, the seller deserves to know, and the seller may have some questions. Like if you're I'm going to keep 80% and I'm going to give 20% to the selling firm, to the buyer's agent's firm, the seller may have some questions. What's going to entice an agent if they're only getting 20%, right? If they're getting a smaller cut. So we just have to discuss this. Firm has advised the seller of the firm's company policy regarding cooperation and the amount of any compensation that will be offered to other brokers, including but not limited to seller subagents, buyer's agents, or both. Brokers who do not participate in listing service and brokers who are not realtors, seller authorizes the firm to check all applicable below. So we're going to mark if we're going to cooperate with subagents representing the seller and offer them the following compensation. Again, not all firms allow seller subagency. So if your firm doesn't do seller subagency, then we're not going to offer anything to seller subagents. And you would mention that in MLS. You would say buyer's agents only in your MLS. Are we going to cooperate? We're always going to see this, I hope. Cooperate with buyer's agents representing the buyer and offer them the following compensation. It's the split that we see in MLS. Whatever you're offering, whomever's bringing the buyer, may that be in-house or cooperating, make sure what you're putting in MLS is not the total commission, but what you're offering the buyer's agents or the seller subagent. If, for example, you put 6% in MLS, how much does the buyer's agent expect to collect? 6%. So make sure you put their split in MLS. Everybody with me on that? Cooperate with and compensate other cooperating firms according to the firm's attached policy. So if your firm has a specific policy in place and you plan on attaching it to the listing agreement, then you check that box. Again, get with your firm's policy on that. Yeah, absolutely. You could check both of these. So if the firm and the seller are willing to work with both seller subagent and buyer's agent, good question. We would definitely check both of those. And whatever we're going to share, is it the same or different, right? However that split looks, depending on how the person is. Yep. Firm will promptly notify seller if compensation offered by another firm is different than set forth above. Agents with cooperating firms must orally disclose the nature of their relationship with the buyer to the firm at the time of initial contact with the firm. So about the time you're scheduling the showing, you're either checking your status and showing time, right? When you go into showing time, it wants to know, how are you showing? Are you showing as a buyer's agent or a seller subagent? And that information gets transferred to the seller and the listing agent. If you call, initial contact, if you call, maybe your buyer wants to see the property, but they have some questions first. So you call the listing agent. You identify yourself as a buyer's agent and initial contact. So we disclose our relationship orally at the time of initial contact. and confirm that relationship in writing no later than the time an offer to purchase is submitted for seller's consideration. So we have the opportunity in our offer to purchase and contract to check our role. You're either a buyer's agent, a seller sub-agent, or a dual agent. So we identify our role when we present the offer. Sellers should be careful about disclosing confidential information because agents representing buyers must disclose all information to their clients. So just a reminder, sellers, warning there. Our agency agreements are bilateral contracts. Who remembers how many sides perform in a bilateral contract? How many sides? Yep. Bilateral. Lateral in contract world means side. So bilateral means it's a two-sided contract. It's a two-way street. The firm has duties and obligations to the seller has duties and obligations to the firm. And in our agency agreement, we have to spell out what those duties and obligations are. So the firm's duties, in accordance, here's our blue note, in accordance with the Code of Ethics, the firm shall, with the seller's approval, in response to inquiries from buyer, disclose the existence of offers on the property. So remember, multiple offers are not a material fact. If we disclose material or multiple offers, we do so with the seller's permission. Where seller does authorize disclosure, firm shall also disclose whether offers were obtained by the individual agent who signed this agreement, another agent of the firm, or by cooperating. So we need to tell the sellers where the offers come from. If you're working with that buyer, the seller has the right to know. If the firm's working with that buyer, we're heading to a dual agency situation, right? So we'll define dual agency in just a minute. Then we list out things that are specific firm's duties. So for example, the firm's number one duty is to find a buyer. That's why they hired us, right? So the firm agrees to provide the seller the benefit of the firm's knowledge, experience, and advice in the marketing and sale of the property. Seller understands that firm makes no representation or guarantee as to the sale of the property, but they agree to use their best efforts in good faith to find a buyer who is ready, willing, and able to make the purchase. I actually had a seller look at me once. We were sitting in their living room and they said, "Can you promise me we'll close?" No, sir, I cannot promise you that. What I can tell you is I will give it everything I got, but I cannot guarantee anything. Y'all be very careful before you make promises or guarantees. Firm has a duty to disclose material terms of offer. Seller acknowledges that brokers are prohibited by the Real Estate Commission from disclosing the price or other material terms contained in the party's offer to purchase to a competing party without permission of the party making the offer. So we cannot disclose terms of other offers without the permission of the person making the offer. This is what's important for us to understand. You and I are held to licensed law and commission rule. The seller is not. So can the seller disclose the terms of another offer? Yeah. It's you and I that can't. This is one reason why I don't like my sellers talking to anybody but me, right? So make sure your sellers know my licensed law and commission rule says I cannot disclose those terms. Disclosure of material facts. Seller acknowledges that firm is required by law to disclose to potential purchasers all material facts pertaining to the property about which the firm knows or reasonably should know, and that realtors have an ethical responsibility to treat all parties to the transaction honestly. So we list it in our agency agreement. I always have a duty to disclose material facts. It doesn't matter how the seller completes the residential property disclosure. I always have a duty to disclose material facts. Other professional services, seller acknowledges that firm is being retained solely as a real estate professional and understands the professional services provided or rendered advice or services to the seller, including but not limited to, and here's a whole laundry list of examples, Again, I'm just an agent. I'm not a contractor. I'm not a plumber. I'm not an electrician. If my seller needs anybody, as example of anybody of these, I can advise them, you know, here's the name of somebody I recommend, but I can't provide this advice. We have got to stay in our lane. Even if you do your taxes, that doesn't make you a tax advisor, does it? So unless you're current on the laws, you need to stay in your lane. Firm may provide the seller name of providers who claim to perform such services. Seller understands that firm cannot guarantee the quality of the service or level of expertise. If you're recommending services, make sure you have a good relationship with them, or somebody in your firm has a good relationship. Seller agrees to pay the full amount due for all services directly to the service provider, whether or not the transaction closes. Seller also agrees to indemnify and hold the firm harmless against liability claims, loss due, damages, etc., as a result of seller selection and use of any such provider, or seller's election not to have one or more of the services performed. We may or may not get a chance to look at it. It's not a required form, but I think it's a very important form. If you guys are familiar with the professional services disclosure, we'll see if we get a chance to look at that one. That's the form that we can go through and help the seller select or waive the service, maybe recommend a service provider. But it's important that the seller knows that I'm just an agent. Another duty the firm provides the seller is to put the agreement to the listing service, to put the property in MLS. Seller acknowledges that the rules of any listing service of the firm is a member of, or in any which firm's agents participate in, may provide a copy of this agreement to any such listing services at its request. Seller consents to firm providing a copy of this agreement. Triad MLS is cracking down. If you're in Triad MLS and you're not aware, then you haven't been paying attention since January 1st this year. Triad MLS is cracking down. And we're getting ready to talk about coming soon, for example. There's office exclusive as well. MLS could call and say, I need to see your listing agreement. And if MLS calls and requests your listing agreement, this is saying we have to provide it. Again, we'll talk about coming soon and office exclusive in just a second. Here's our non-discrimination clause. The agent in the firm shall conduct all brokerage activities in regard to this agreement without respect to the race, color, religion, sex, national origin, handicap, or familial status of any party or prospective party. Further, realtors have an ethical duty to conduct such activities without respect to sexual orientation or gender identity of any party or prospective party. We're actually going to talk about our protected classes in just a bit, so we'll see these again. This is probably going to be an update in the forms that we see. I hope so this year. As of February 2021, sexual orientation or gender identity fall under sex with federal fair housing. So as of February 2021, it used to just be they were protected by NAR, but as of February 2021, sexual orientation and gender identity officially falls under the category of sex with fair housing. So I'm thinking, I have no idea of knowing, but I'm thinking that might be an update we see with our new forms in July this year. Why is the MLS cracking down so hard? Because agents abuse it because we don't follow the rules, and they're tired of us not following the rules. Have you guys been to MLS training? MLS's trainer is Karen Dietz, and I went to some of this training at the beginning of the year. I'm telling y'all, Karen is frustrated with us. She is tired of saying the same thing over and over and over again, and we're not listening. So MLS says, fine, if y'all don't want to listen, we're going to put fines on you. We're going to give you warnings. We're going to crack down. So they say that all these rules that we have in place today have always been in place. They're just now enforcing them. I guess that would be a better way for me to say that. That's what's changed, is they're now enforcing them. But yeah, I went to a couple classes that Karen led, and I thought my poor girls had it up to about here. You guys thought the same thing? She's sick of us not following the rules, y'all. So they're going to slap fines on us now. See what happens when we don't follow simple rules? Karen Dietz. She was a listing agent of my condo when I bought it back in 2006. It was like one of her last transactions before she went into MLS training. Isn't that funny? I have the honor of saying she was the listing agent. Small world. Red warning, addressing buyer letters to sellers. We call these love letters, heartstring letters. To entice a seller to choose their offer, some buyers write personal letters to sellers expressing why they wish to purchase a seller's property. Such letters often contain personal information and reveal characteristics of the buyer, which could be used knowingly or through an unconscious bias as a basis for the seller's decision to accept or reject an offer that may violate state and federal fair housing laws, or be used to form the basis for a claim that the seller and possibly the seller's agent have violated fair housing. In order to avoid potential liability or unlawful discrimination, as well as the appearance of improperty, and what's that word? Improper, we're going to say improper. Sellers should discuss with firm how such letters should be submitted, will be handled. Again, NAR is cracking down on love letters. They haven't come out and said, don't do it yet. But they're saying, if you do it, my gosh, you have got to be careful. Your firm should have some kind of policy. Think about it. A buyer submits an offer with a love letter and they say, I can imagine my family sitting around Christmas morning celebrating together. We just, in one sentence, we just touched on two fair housing protected classes, didn't we? Familial status and religion. So it's so easy when the buyer is explaining themselves, you know, why you should pick me. It's so easy for us to cross that line, and that's the warning. For those of you that are active, have you started seeing in agent-only remarks, love letters will not be delivered as a part of this offer? Have you guys started seeing that? So you're addressing it up front, and that's what our listing agreement is suggesting. If you deliver a love letter, I'm not delivering it to my seller. Bottom line, the seller should care about money, and if the buyer has the funding, can they get the financing? Do they have the proof of funds? And that's all a seller should care about. Help keep them caring about pointing in what's important. Comments on these love letters?
I have found that buyers will ask, like, what do you know about love letters? And I heard that we could write love letters.
Because they had a friend of an aunt that did it once, right? So, yep. And, you know, again, your firm policy may just, well, you know, let's have a strong offer. We don't do love letters. Instead, let's have a strong offer, right? So your firm's policy very well may dictate. Again, you guys, NAR has not come out yet and said, don't do it. NAR has just said, be really, really careful. There was an article the Real Estate Commission published in the bulletin about these a couple months ago as well. Yeah, Plummer.
No, I was just going to say, I think they haven't made a statement because they realize how sensitive it is. Might be treading on some amendment issues. So
could be.
I'm sure their attorneys are looking at it.
You know, I don't know if you guys know or not, but NAR is currently in the throes of a lawsuit from the Department of Justice. So they're getting picked apart pretty carefully right now. You go to Google after class, please don't do it now. But you can, I don't know the current status of this lawsuit. That's part of, Donna, might be why our local MLS is cracking down, because we're trickle down from NAR, right? NAR to the state level to our local board of realtors. So part of why they're cracking down. I know we talked last week about flagged words in public agent or public remarks. So if you put in white cabinets, they're going to flag that just to make sure you're using the word white appropriately. That's come from NAR. And I think that's a result of this ongoing lawsuit. So we might see some more things, Plumber, as they start picking NAR more and more apart. Hopefully it doesn't affect us. One thing they're being accused of is price fixing. And NAR is like, we have never told anybody what to charge, you know, for commission. So DOJ is just, they're going after them full force. I don't know what NAR did to upset them, but they're they're after them now. So I don't know, we're trickle down, right? We absolutely could see more results of that. But again, with love letters, just check with your firm's policy, see how they want you to handle that. And then the last part of this provision, the seller acknowledges that seller's been made aware of each firm duty described above in this paragraph. So the seller needs to initial these two places. Again, you guys, sellers aren't reading this. This is part of our job too. This should be part of our listing presentation, right? We're not going to sit down and read it to them as part of our listing presentation, but take these things that you promised to do and make it part of it, right? So they understand what services to expect from you and what not to expect from you. Put this as part of your presentation, your conversation with sellers. Questions so far? Okay. Before we get into marketing, let's go ahead and take our break. So let's take 10. We'll come back at 11:06. We'll talk about marketing the property. All right. Everybody good so far? Just good to pick this apart. I always think it's helpful to sit down, go through this listing agreement, all of our forms, as a matter of fact, help pick it apart, make sure we understand. Again, our sellers aren't reading this, you guys. So we need to make sure that we help them understand. Next provision talks about marketing. So remember, we identified when we're gonna either at the effective date or if it's already listed. Now we have to address commencement of marketing. The firm, well, there's a couple different things. The firm is authorized to commence marketing the property described below on this date. Firm is obligated to present to seller any offers of the property that may be submitted to firm prior to marketing date. This is what the provision we're going to use. Let's say you get this thing signed today by your sellers. That's the effective date, right? We get it signed today, but we're not going to market it until Tuesday. That gives us time to get our pictures, get our measuring, get this last information, get it MLS. So if you're going to put it in MLS on a date different than the effective date, then you use this marketing date. Is everybody good with that? And I think this is the most common because, again, I'm not saying it can't be done, but I'm saying it's going to be awfully hard to get it signed, pictures, measuring, and MLS all on the same day. If you can do that, you are my hero. I am impressed with you. My team, for example, we have a general contractor that does all of our measuring. He takes our pictures. So part of my listing procedures is to line him up, right? Find out his availability, find out when he can get out to the property to measure and take pictures and that kind of thing. So we always use the marketing date. He wants to know that the seller's on board before he goes out. So we want it signed, but we may market it at a later date. Even if you're not marketed yet, if an offer comes in, we're obligated to present to the seller. Our blue note says it is in the best interest of most sellers to get the highest possible price on the best terms for the property. Maximizing exposure to their property advances that interest. Accepting an offer on the property before it's fully exposed to the widest group of potential buyers may deny a seller this best opportunity to attract offers at the highest price and terms available. I'm going to say it comes down to the seller. Some sellers want to go on the market and pit everybody together and see what they can get. Some will take, in this market, our buyers are competing with investors. Let me rephrase that. Our buyers are competing with cash investors. And I swear these cash investors are just sitting at their laptops hitting refresh. And as soon as something hits MLS, they're making a cash offer. We can't even get buyers in the property in some case. Does your seller have to accept that investor's cash offer? Not at all. They very well may want to have 3 days of showings before they decide which one. You guys with me? So we present the offers. They make the decision. Some sellers are going, God, I don't want to deal with 3 days of showings. Yes, let's just go into, it's up to the seller. It's a conversation we have with that seller. Yes, that's the other thing investors are doing is putting offers in sight unseen. I had a coworker that put hers on as coming soon. We'll talk about coming soon in just a second. Coming soon means we can't allow showings. We'll talk about that. So she had investors make offers sight unseen while in coming soon. And one of them submitted an offer and said, this is what I'm offering you now. If you show me interior pictures, because she didn't have any interior on MLS, she just had a couple exterior. They said, if you send me interior pictures, I'll up my offer by X amount. So they created a contingency that says, email me pictures. And she did. And they said, all right, yeah, we'll do it. So they, they honored their word. Buyers are getting upset and understanding, I know, and it's hard to explain it to them. Bottom line, what buyers are saying is that's not fair, but they're competing with investors, cash investors that, like you said, are willing to go sight unseen. And that's an unfortunate part of the market that we're in for buyers. That's also affecting our rental market, isn't it? Because investors are scooping these things up like mad. And now they can rent not cheap. Let's just put it that way. It's tough
Julie-
out there right now. Yeah.
No, I was gonna ask, I guess the rest of the class, it appears some people are sending you questions directly to you and we don't see them.
Correct.
So it's
That's
a little
what I'm discussing.
it's a little disjointed. I know you're doing
It-
your
it-
best explaining the question, but it's
Okay, so I'll read it. How about that? I'll read
Yeah,
it when they come
thank
into
you.
me as a direct message. Thank you, Plummer. So the latest comment says, or putting in offers sight on scene. So that's what I was responding to that. And then they said buyers get upset and don't understand
Hmm.
why they're going under contract, within a day or so.
All right.
So that just comes back to us to make sure that we're explaining it to them.
Thank you.
Okay, thank you. Then we have marketing authorization. So we're told, and this is important, you guys, this is another reason why I think MLS is cracking down. We're told to initial public marketing or office exclusive, but not both. So we have to decide, are we going to do public marketing or are we going to do office exclusive? So let's talk about both. If your seller's initial, or if you check, whichever one you want to do, public marketing, firm shall submit pertinent information concerning the property to any listing services of which the firm is a member, or in which any of the firm's agents participate in according with the rules of such listing services. A seller authorizes firm to furnish to the listing service notice of all changes of information concerning the property. Seller authorizes the firm upon execution of a sales contract to notify the listing service of the pending sale and the expiration date of any due diligence period. And seller authorizes the firm upon closing of the sale to disseminate sales information, including sales price, listing service, appraisal, and real estate brokers. So we have to have the seller's permission to put it in MLS. We have to have the seller's permission. Well, Triad MLS dictates how long do we have after it goes under contract to change the status? 1 day. 1 day. It goes under contract. We change that. We have 24 hours to change that to under contract. Again, the seller can't dictate for us, right? Those are the Triad MLS rules. Again, these are kind of things that we're starting to see crack down on a little bit. If you're going public marketing, seller authorizes the firm as follows. Coming soon advertising. To market the property as coming soon, commencing on the marketing date, and any media firm may in its discretion select, provide that any coming soon advertising shall be conducted in accordance with any restrictions and requirements of any listing service in which the property will be included, a copy of which are or are not attached to this agreement. The status of the listing shall be changed to active on this date. Triad MLS has a coming soon addendum. And if your sellers are going to do coming soon, you're only advertising. You cannot allow showings. Nobody can see it in your firm, and you guys need to talk to your sellers too. Because you know what buyers are doing when they're seeing coming soon? They're going to the dang house. They're ringing the doorbell and they're saying, can I see your house? So we need to make sure that our sellers understand that nobody, no matter where they come from, can see the property when it's coming soon. Triad MLS says we can go coming soon for 21 days. So up to 21 days. So you put the date in. Again, if you go coming soon, check with your local MLS if you're not in Triad. But there is a form and it has to be added as an MLS attachment for all agents to see that coming soon addendum and what date you're going to go active. The seller has to authorize the firm to put a for sale sign on the property and to remove such signs when it's over. Not all sellers want a sign in their yard. So we have to have this discussion. I listed one yesterday and my teammate called me and said, we're getting a listing agreement amended. The sellers decided they didn't want a sign. I said, all right. So they went in and had this changed and had it amended. I don't know why they changed their mind, but they decided they didn't want a sign in the front yard. Maybe they don't want the nosy neighbors to know their business. Who knows why? Seller authorizes the firm to do an open house. Firm subsequently agrees. This doesn't mean that you have to do an open house. This is just if you can do an open house or not. Ooh, that's a good point, Chastity. Thank you. Some HOAs regulate how your restrictions on your signs as well. Thank you. So check with your, I had a townhouse listing once and they said nothing in the yard. So I had to put the sign in the dining room window, right? The dining room faced the parking lot. And I had to put the sign in the window because they said nothing in the yard. Seller advertise or allows firm to advertise other than the internet. To advertise the property in a non-internet media and to permit other firms to advertise the property. Seller has to allow us to do internet advertising, to display information on the property on the internet, of any listing service which the firm is a member and the firm's agents participate. Seller further authorizes other firms who belong to the listing service and who's a member of which any of the firm's agents participate to display information about the property. So this isn't just putting it in MLS, it's also allowing the MLS feed to go to cobblebanker.com and allentate.com and bhhs.com, right? All those websites that you see listings for sale, it all starts from the MLS. And the seller needs to understand that it's going to go to all those places if they allow. Seller specifically authorizes the display of the address on the property, automated estimates of the market value, third-party comments. If seller desires to limit or prohibit internet advertising, then we have an opt-out form that the seller has to complete. And NCAR helps us out by telling us that opt-out form is Form 105. Again, this could come down to firm's policy, but if your seller doesn't want internet advertising, then they need to opt out using Form 105. Guys, sellers need to know we're getting ready to plaster the inside of their home all over the internet. So encourage your sellers to depersonalize before you take pictures, before you market, especially pictures of kids, you guys. Let's not give people a reason to scour listings looking for various things. So have them depersonalize to protect themselves. Don't put, pictures of the gun cabinet in MLS. People might be looking for that kind of thing to scope it out, right? Try to take pictures of the space. That's what we're selling, isn't it? I'm not selling stuff. I'm selling space. So the more we can declutter, the more we can get stuff out, the bigger the space looks. Have you ever been in a room that's jam-packed full of furniture? It doesn't look real big, does it? You start taking some of that furniture out and it looks a little bit bigger, and that's what I'm trying to sell. Comments on that? Y'all ever see bad pictures in MLS? You think, what are they taking a picture of? Why are they focused on the bed? Are they selling me the bed? So sometimes take a few steps back and try to get the area that the bed is in. And y'all, please, for the love of everything, put the toilet seat down before you take pictures of the bathrooms. Come on, that is my #1 pet peeve right there. When I see a toilet seat up, you too, thank you. Drives me, I will click past a listing faster than anything when I see that. It's the little things that make a difference. We all know what goes on. We don't need a picture, come on. My ex-boyfriend's mom and stepdad sold their house many years ago. And it was one of those breakups, like we broke up and I was like, man, does this mean I can't hang out with your mom anymore? Right? Because her and I got along beautifully. But evidently they're a package deal. So that severed our relationship as well. So after we broke up, they listed their house. And of course, I'm all over it looking at pictures and everything. And one of the pictures of the spare bedroom, sure enough, on the nightstand is a picture of me and him. And I was like, she should have taken that down. And then on one hand, I'm going, oh, she still thinks of me. I'm still in her spare bedroom. But then on the other hand, I'm like, God, we are still on the internet. I wish she would have taken that down. That was eerie. Just be careful what you put on the internet. So coming soon, public marketing, various things that we check with public marketing. Remember, we have two choices, public marketing or office exclusive. If you select office exclusive, Can anybody outside of your office be made aware of this property? No, these are properties for internal use only. MLS has even said, be careful about talking about it to non-realtors. You can't market it to anybody. So don't mention it to your home inspector buddy, because now you've advertised it outside of your office. Everybody with me? Office exclusives is exactly how it sounds. Seller withholds consent for the listing to be publicly marketed, including social media, and disseminated to other participants of any listing service of which the firm is a member, or in which any firm's agents participate. Seller understands and acknowledges that the rules of any such listing service may require the listing be filed with the listing service, or that the listing service may be notified of the listing, but that the listing will not be disseminated to the listing services participants. And the listing service may require a firm to provide certification signed by the seller that this listing shall not be disseminated by the listing service. We have an office exclusive, Tried MLS has an office exclusive addendum. If you're doing office exclusive, you're putting it in MLS for comp purposes only. My firm, we don't put it in until it closes. So it never hits the market. So if we have an inside deal that is never public marketed, then we put it in when it closes, just so the appraisers and other agents can use it for comp, CNAs, that kind of thing.
Julie,
Firm is
what would be the reason to do office exclusive? I mean, what benefit, I guess?
Maybe you have a buyer and a seller that you want to connect, right? That, you know, maybe the seller doesn't want to list, but you know of a buyer, so you can connect them. Not all sellers like the idea of having buyers trampling through their homes, you know? So maybe if you know of somebody and you can connect them without the seller going through this. My firm works with several investors, and the investors know what they're looking for. So if we catch wind of a property, we might be able to connect them, you know, before it ever hits the market. So there could be benefits. The seller may say, well, I want 3 days of showing so I can see all the offers that I'm going to get, you know? So it's a conversation that we have to have with our sellers. Like I said, not everybody's happy, especially in this market, about having buyers. I mean, it's a constant parade, right? That front door is a revolving door in some cases. Did y'all see that video in Raleigh a month ago? There was the buyer's agent that was showing property, and she just stood on the front porch. And so there was like, what, 10 people hanging out in the yard, and the cars were parked up and down the street in the cul-de-sac. And some sellers don't want that. But the point here is that you're no way marketing it publicly. You're keeping it internal. Firm is prohibited from marketing the property publicly, including any methods listed above: signs, internet, non-internet. If at a later date the property shall be marketed publicly, this agreement must be amended. So if the office exclusive doesn't work out and you're going to put it on public, we need to strike through this initial and come back and have our sellers initial public marketing. We also have to send, again, Triad MLS. I'm not familiar with other MLSs, but with Triad MLS, we also have to send the office exclusive to Triad MLS along with our listing agreement, and they both better be signed on the same day. So if you're ever doing an office exclusive, we need to notify in the Triad. If you're not in Triad, check your MLS. Our blue note, the listing must be submitted to the listing service and disseminated to its participants. This is what we're doing by sending it to MLS within 1 business day of any public marketing, or if the property is required by listing service rules. Public marketing includes, but is not limiting to, flyers displayed in windows, yard signs, digital market, public facing windows or websites, brokerage websites, digital communications, email blasts, multi-brokerage listing sharing networks, and applications available. So again, if I may sum all that up, you are prohibited from marketing this property publicly. That's what office exclusive means. Questions on that? Continuing on with our marketing authorization, whether we're doing public or office exclusive, seller does or does not authorize the firm to place a lockbox on the property. If they don't want a lockbox on the property, then the listing agent probably needs to be available to let buyers agents in. Or somehow we need to make arrangements to get them in. Seller acknowledges and understands that while the marketing services selected above will facilitate the showing and the sale of the property, there are risks associated with allowing access to and disseminating information about the property that are not within reasonable control of the firm, including but limiting to authorized use of a lockbox or a key box. I have no control. I mean, at least if you use an e-box, you can pull a report to see who has accessed it. But if you use a combo box, you have no control. Once they learn that passcode, they can get in at any time of the night too. So help protect your sellers. Firm has no control over the visitors during or after showing or an open house, including the taking and use of photographs and videos of the property. Buyers can go through and take pictures. They can go through and take videos of the property. That doesn't say of personal stuff, does it? Let's say you have, maybe you have a couple that wants to see a property after work. You agree to meet them at 5:30. You show up at 5:30 and one of them got delayed at work and couldn't come. The one that did come, they want to go through and snap pictures for their spouse, for their significant other, to show them when they get off work, right? To see if they're interested. I encourage my buyers, if we're looking at 13 properties today, I encourage my buyers to take notes, take pictures, because I'm telling you, if you're looking at 13 homes today, they're all going to run together. So have your buyers take notes. Again, you guys, we are with our buyers for a showing. We're not just opening the front door and saying, have at. We're following them and we're making sure that they're taking pictures of the space and not the stuff. Make sure they're not scoping the joint out. Open houses, I don't have as much control over open houses than what I do me showing property to a buyer. So again, protect your sellers, have conversations with them. The firm has no control over inappropriate use of information about the property placed on the internet or furnished to any listing service in which the firm participates. I had a for sale once somehow show up on a for rent website. I don't know how that happened. It's something with the IDX feed. My seller said they were sitting there one night watching TV and they noticed somebody in the window coming and looking in the window. They came from the for rent sign. So guys, sellers don't need to open the door for anybody that they don't know, right? Be very, very careful. Again, have conversations with them about their safety. I had no control over that possible tenant, or so they thought, showing up and looking in the windows. You know, I said, my God, what did you do? They said, they said, we're not going out there and talking to them. We don't know who these people are. I said, good for you guys. So I don't know how information gets to the places that it gets, but have conversation with your sellers to protect them. And especially I would encourage them not to open the door for anybody that doesn't have an appointment through showing time. I think that's the best thing we can do to protect our sellers. Information, no control. The firm doesn't have control about information about the property placed on the internet by or through the listing service in which the firm participates, which is inaccurate or dated, or information about the property which may remain on the internet following the expiration date, including but not limited to photographs. I have zero, and I mean zero, control over Zillow. Zillow pulls the feed, for example, from MLS, and I have zero. I can go into Zillow and edit it, but as soon as they pull the next feed from MLS, it's going to override it. So sometimes the wrong information gets transferred. The only thing I control is MLS. That's it. Once it leaves MLS, it's out of my hands. And sellers need to understand that. After closing, you might get a call. Those pictures are still up. That information is still up. Hopefully it'll come down soon. Seller acknowledges and understands that neither the firm nor its agents have any control over information about the property that's been placed on the internet in connection with marketing, whether by or through a listing service, including but not limited to pictures, and that information will not be removed. We pretty much just said the same thing there, didn't we? Seller agrees that seller is solely responsible for securing all valuables, cash, jewelry, firearms, medication, tools, and other items of personal property during the term of this agreement. So again, have a conversation with your seller. North Carolina Real Estate Commission did an educators conference a couple weeks ago. And one thing we always do at our educators conference is like the state of the commission address. And they talk about the most common complaints hitting the commission right now. And one of the most common complaints hitting the commission right now, they have video of buyers and brokers taking prescription medication. They're opening cabinets, they're finding them, they're putting some pills in their hand and putting them in their pocket. Guys, buyers have a right to look in kitchen cabinets, closet doors, right? Things that are going to stay. Kitchen cabinets and closets are not the place to put valuables, medications, that kind of thing. Have your seller, because they should be looking in there anyway, right? If it's going to remain, they have the right to look in there. Now, obviously, dresser drawers and desk drawers wouldn't apply. So have your seller put this stuff not in places. Commission has had numerous of complaints this year, specifically about prescription medications, because they're in the kitchen cabinet. You open the cabinet, you go, sweet, this looks good. Grab yourself some pills. And they're on video. Y'all, it's 2022. We should all be conducting our lives as if we're on video. Because you know what? There's a really good chance that we are, especially if you're inside somebody's home. There was a disciplinary case last year, maybe about a year ago, coming up on a year ago. The agent got to the home early before her buyer. So she was going through and opening light, turning lights on, opening the house. And while she was getting the home ready to get ready for her buyer to show up, she stopped by the bar and made herself a cocktail and stood there and had herself a drink from the seller's bar, waiting on her buyers. And the seller sat and watched the whole thing on video. She wound up in the disciplinary action. Wait till after the showing to go out and have a drink. Don't try to do it when you're, and certainly don't, that's called stealing, when you take something without permission. Did you see that too, Chastity? I saw you. Like, come on. That's the fun thing about this industry. We don't have to make stuff up. It actually happens. All right, let's see what else we got. Seller therefore agrees to release and discharge firm and firm's agents, permitting all claims, demands, rights, and causes of actions of whatsoever kind and nature not caused by firm's negligence arise directly or indirectly out of such marketing. Again, the best thing we can do to protect our sellers is have these conversations up front. Have them depersonalize, have them take down. Then we got a big red warning. It may be a crime under federal and state laws to listen to or record an oral communication through the use of any electronic, mechanical, or other device without the consent of a party to that communication. If there is video, audio surveillance devices on the property, sellers advise that no audio surveillance device may be turned on during the showings, open house, or investigations, examinations, or inspections of the property, and that the placement of any video surveillance device shall not violate a visitor's reasonable expectation of privacy. Conversation with your sellers. You can have video, you cannot have audio. And this video need not be in the bathrooms. With that being said, I still caution my buyers before we walk into a house. I have no reason to think that all sellers follow the rules. And I don't want to harm my buyer's negotiations power. Just because they're not supposed to have audio doesn't mean that you're not going to come across some that do. Ring doorbell. If you're standing and talking about it, chit-chatting about it on the front porch, if they got their Ring doorbell on, they need to turn the audio off. So we need to have the conversation with the sellers, absolutely. But just in case, as a backup, have this conversation with your buyers as well. I don't care about the buyer walking in the front door and going, oh God, this carpet is tacky. I don't care. That's their opinion. They're entitled to that. What I don't want is the buyer walking in the front door and going, oh, this is it. This is the house I've been looking for my whole life, and I will do anything for it. The seller's sitting there listening on their phone, hearing what? Cha-ching, 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 right? They got money signs going on. So some buyers are adorable. I love them. I can't get them to say a word in the house. Maybe I did a good job of explaining this to them. I don't know. But let's wait until we are safely away to have conversations. Again, have this discussion with your sellers. Video, yes. Audio, no. Comments on that? And this is only going to get more important as technology continues to grow. Earnest money. Firm does or does not maintain a trust account to hold earnest money. Any initial and additional earnest money deposits and any other earnest monies paid in connection with any transaction shall be held by an escrow agent named in the contract until consummation or termination of the transaction. Any earnest money forfeited by reason of the buyer's default under the contract shall be divided equally between the firm and the seller. What? That comes down to your firm's policy. Our contract says, our sales contract says, if the buyer terminates after due diligence, the seller gets the earnest money. Our listing agreement says that if the seller gets the earnest money, that earnest money is to be divided equally between the firm and the seller. Your firm's policy will dictate if they expect to collect earnest money and how much, if so. So check with your BIC on that.
Can you say that again?
What's that?
The part about starting with the due diligence part.
If the buyer terminates after due diligence, the seller gets the earnest money. And if the seller gets the earnest money, the listing agreement says that that could be divided equally, shall be divided equally between the firm and the seller. Whether or not that's going to happen is up to firm's policy.
So Julie, if this was a test question, what would we go by? This or?
Well, it says it shall be divided, right? You can't be tested on firm policy
Okay, cool.
because
Okay.
every firm has a different, now your firm may test you on their policy, but the real estate commission can't test you on firm policy. So if this were a test question, the listing agreement says that it shall be divided equally between the firm and the seller. Okay. In no event shall the sum paid to the firm because of buyer's default be in excess of the fee that would have been due if the sale had closed. In accordance with this general statute, if a dispute regarding the term or the forfeit of the earnest money revises between seller and buyer, escrow agent holding the deposit may deposit disputed monies with the appropriate clerk of courts. In the event of such dispute, seller directs firm disclose seller's last known mailing address to the escrow agent. You'll talk more about earnest money and disputes in 302. So if you haven't taken 302 yet, we'll talk more about that. Bottom line, the escrow agent can't release the earnest money. If the contract terminates, the escrow agent can't release the earnest money unless they have consent of both parties. So if the earnest money is in dispute, the escrow agent hangs on to it until the dispute is resolved, or they can turn it over to the clerk of courts and let the two go hash it out in front of a judge. You'll talk more about that in 302. Questions about that? The seller has to make representations to the firm. So seller representation, they got to represent how long they've owned the property. They've owned it for at least 1 year. They've owned it less than a year, or they do not yet own the property. This could be information that the lender wants. This could also be for tax purposes. So the seller discloses how long they've owned the property. If the seller does not yet own the property, seller agrees to promptly provide firm information pertaining to the seller's acquisition of the property, such as a copy of the contract, and to keep firm timely informed of all development pertaining to the seller's acquisition. The absolute best example I've ever heard about this one, and you guys may have others. There was a case where the buyer was building and the builder worked as a package deal. So the builder purchased the land and then built and then turned around and sold the whole thing to the buyer. The builder was still in the process of purchasing the land. The builder did not yet own the property. They were under contract and we were close, but the deed wasn't in their name yet. Anybody heard of another example of this? Again, if they don't own the property yet, just make sure that they're on their way to purchase it. Seller has to represent if they are or are not facing bankruptcy, is or is not under bankruptcy protection, is or is not contemplating bankruptcy. Seller has to represent the access to the property. Property has legal access to public right of way. If access is a private road, easement, etc., there is or is not an agreement regarding the maintenance of such private road or easement. If applicable, seller agrees to promptly provide firm with information pertaining to such agreement. If there's a manufactured home on the property, we're told to complete only if there's a manufactured home on the property that the seller intends to include as part of the sale. If it's going to convey, we need the VIN number and another description, so year, model, etc. Seller represents if they are part of an owner's association. Again, we're instructed to complete only if the property is subject to regulation and or assignment by an owner's association. So we want the name, address, and phone number of the president of the owner's association or the association manager. What's the website of the association? And you may have places that have two HOAs. Maybe, for example, one is mandatory and one is optional. Some will say you have to join the HOA and you can choose or not to join the pool, for example. So if there's multiple HOAs, then we have a place to list two. If you have more than two, get a piece of paper and ask some questions. Receipt of sample form. Seller acknowledges receipt of the sample offer to purchase and contract. Seller acknowledges receipt of the sample professional services disclosure. Only check these boxes if you provide your seller with these sample forms. If you don't provide sample forms in your listing package or part of your listing agreement, then don't check these boxes. You only check these boxes if you provide these sample forms. Each of the following is made to the best of the seller's knowledge. Flood hazard. Property is or is not located partly or entirely within a designated special flood area. The seller does or does not currently maintain flood hazard insurance. It might be that the property is in, the land is in a flood zone, but the home is not and does not require insurance. So these are actually two separate questions. Just because a portion of the property is in a flood zone does not automatically mean they have to pay flood insurance. So there's two specific questions to ask your seller. Synthetic stucco. The property has been clad previously, either in whole or in part, with exterior insulating and finish system, known as EIFS or synthetic stucco. Once a property has been clad in synthetic stucco, whether it's been fixed or not, it will always remain a material fact. So we touched on this, I think, last week when we looked at our material facts. Even if it's been repaired, it is still a material fact. Termite bond, there is or is not a termite bond on the property. If there is a termite bond, it is or is not transferable. The cost to transfer is X amount, the bonding company is whomever. So if your seller says, yeah, I have a termite bond, you can request information to verify that. You can make sure, and they can find out if it's transferable or not. And then we get to current liens. The property is or is not encumbered by a deed of trust or a mortgage. Complete any of the following where applicable. And then I have 1, 2, 3 places to list various liens. So here's the lender name, the approximate balance, and their phone number. Note this says approximate balance. We're not going to get the actual amount due until we have a closing date, right? That's when we're going to get the information. We're just listing the property. I have homeowners on the call. When you guys get your monthly mortgage statement, you see a number and then there's an asterisk, and the asterisk says this is an approximate, this is not an actual payoff amount. That's how we can get that information. When you want an actual payoff amount, you need to contact the company and specify a date, because there's various things to take into consideration when getting that balance. This is our opportunity, guys. Sellers and brokers do a poor job at this. This is our opportunity to make sure that the seller can afford to sell. If this list starts adding up, and if they have more than 3, then we need to attach a separate piece of paper for them to put all their liens in. And if you start adding up all these balances and you realize that they owe more than the house is worth, this is the point for us to have a flag to stop and ask some questions. We're going to talk about short sales in a bit. Are they facing foreclosure? If they're bringing money to the closing table, can they afford to sell and pay your commission? Y'all, please don't wait until the day of closing for your seller to say, I can't afford that. Now the seller's in breach, and guess how much you're going to get paid? Nothing. Wouldn't you rather hash this out before you sign the listing agreement than wait till you get to closing? I sure hope so. And guys, if they're underwater and they're broke, even if you sue them, how much commission do you think you're going to get out of them? What's that old saying? You can't bleed a turnip, can you? So this is uncomfortable. I just met this seller last week and I'm standing there going, how much do you owe, right? This can be very uncomfortable. You're doing it to protect yourself. You're doing it to protect them. Do I have any comments on that? Again, we'll talk about short sales briefly in just a bit. Again, seller is or is not encumbered by a deed or trust or mortgage. Seller is current on all payments for the loans identified above. So that's the second part too. How much do you owe, and are you current on your payments? What happens if they're not current? They could be facing foreclosure sooner than what we realize, right? So it's a twofold question. How much do you owe, and are you up to date? Seller is not in default on any loan identified above and has not received any notice from the holder of any loan identified above, or from any other lien holder of any kind regarding a default about the loan, threatened foreclosure, notice of foreclosure, filing foreclosure, except as specified below. So the seller saying they're not facing foreclosure. There are not any liens secured against the property for federal, state, or local income taxes, unpaid real property taxes, unpaid condo or owners association fees. Here's our mechanics liens, or any other liens affecting the property, and the seller has no knowledge of any matter that might result in a lien affecting the property, except identified below. There are no judgments against the seller affecting the property. Seller has no knowledge of any matter that might result in a judgment, except as identified below. And there are no uniform commercial code fixture filing affecting the property. The UCC is what regulates our personal property. So if you have a rent to own, for example, a lease to own appliance, maybe a hot water heater, that falls under the UCC. And seller has no knowledge of any matters that might result in a UCC fixture filing affecting the property, except identified below. And 7 is where the seller fesses up. If any of these, 1 through 6 don't apply, then the seller needs to specify here. So we're getting awfully personal, awfully fast with our sellers, aren't we? But we're doing it to protect them and ourselves. Here's a note. I think that's more for the sellers than us. Outstanding liens may affect your seller's net proceeds. Remember, we're working through that net worksheet with them. Everybody else gets paid. The last person to get paid in the transaction is the seller. Anything outstanding, they've got to pay off first. What questions or comments do I have about that? It's awkward. You're being nosy. Why do you care about my finances? Because I don't want to waste my time. I would come up with a better way of saying that than you, but I don't want to waste my time. I don't want to waste your time. Put that in your own words. I don't know. Maybe sometimes people need to hear blunt, Let's see. Seller represents if there's leases on the property. Property is or is not subject to any leases. If applicable, the seller agrees to promptly provide a firm the copy of leases or written statements of the terms of any oral leases. Remember, our Connor Act and our statute of fraud says leases less than 3 years don't have to be in writing. So just because you have a lease not in writing doesn't mean it's not valid. Connor and statute of frauds weigh in on that. If the property is managed by someone other than the seller, the manager's name and contact information is. So who's the property manager? That's who we should be communicating with if the owner's hired a property manager. Seller authorizes any such manager to release and disclose to firm any relevant information about leases and to cooperate with the firm in the sale. So if we have an existing lease in place, we need to identify that. FHA appraisals. FHA appraisal has or has not been performed on the property within 4 months prior to the effective date. If applicable, seller agrees to promptly provide firm a copy of the appraisal. That's because an FHA appraisal follows the property. So if the seller has had an FHA appraisal and your buyer's getting an FHA loan, they will rely on that FHA appraisal for 4 months. So we need to know if we have any. Yeah.
Julie, do new home constructions get appraised?
If the buyer's getting a loan, because it's not, the appraisal's not the buyers, is it? The
Right.
appraisal's the lenders.
So the
So if
bank,
the lender's issuing a
Yeah.
loan, they're going to require, absolutely. Absolutely.
have you seen instances where what the new home construction company is listing for is different from what the appraiser? Because I know they put the little caveats there and ask, are you willing to, the appraisal gap?
Yep. Yep. Is the seller required to drop the price to match the appraisal?
Mm-mm.
Nope. The only thing the appraisal is telling the lender is how much loan to issue. Right? Seller can't be forced to change any terms. So. And this note tells us here, any such appraisal may or may not be binding on a buyer who intends to obtain an FHA financing. And that's just because FHA follows the home. FHA appraisals follow the home. Other questions so far? We're just trucking right along. We're close to the end of this. We got to go through the listing agreement. I'm sorry, the buyer's agency agreement too, but we're not going through it near this detail because a lot of this stuff is redundant. So I appreciate you guys' patience. I know forms aren't the most exciting things, but I hope you guys see the value in going through these forms because there's a lot of information in here. And again, if you guys think your sellers are sitting down reading this, I'm here to tell you, you are wrong. It is our job to explain this to them. So that's why we go through it in the detail that we do. Fair enough? Fair enough. All right, let's take a break. So I got 11:56. Let's come back at 12:06 and we'll continue. All right. Welcome back. We're almost done with the listing agreement. We spend the most time in this class talking about sellers, and a lot of what we talk about sellers applies with buyers as well. So the buyer section is a little bit smaller. Like, for example, how we can solicit business. We talked about NAR says we can't solicit somebody else's client, do not call rules. You know, we talked about that with the sellers, but that applies when you're soliciting business from your buyers as well. So continuing on. FHA appraisals, where we left off. Special assessments. Special assessments can come on by an HOA or government. The government might put a special assessment on if they're going to hook an entire neighborhood up to public sewer, for example. What if they're going to install sidewalks or street lighting? So the government may put on a special assessment. The HOA can put on a special assessment as well. Maybe they're going to redo the roofs or repave the parking lots of a condominium or a townhome community. The seller is representing to the firm that there are no special assessments as defined in our sample offer to purchase and contract regarding the property that have been approved or under consideration, except as follows. So if there are any special assessments approved or under consideration that the seller is aware, then they need to represent that to the firm. Seller represents that there is or is not a fuel tank located on the property. And we got a place, use of the tank, we got a place for 2 different tanks. So we go through this little exercise twice. There's tank 1 and here's tank 2. So use of the tank currently is in use or not in use. Who owns the tank? Is it owned or leased? Where is it located? Type of fuel. And then the refilling schedule, name and contact of the vendor, contact of the vendor, and then if there's 2 tanks on the property. So the seller represents that to the firm. If during this agreement, the seller becomes aware of any representation set forth in this paragraph are incorrect or no longer accurate, then seller shall promptly notify the firm and cooperate with the firm with taking appropriate action. So if the seller finds out later they misrepresented the fuel tank, for example, they need to notify the firm so we can change the listing agreement and let any interested parties know. So if you have a buyer's agent that presented an offer, maybe they tell you an offer's coming. If you have an interested party, help them know those changes. Two-way street, we talked about the firm's duties to the seller. Now we talk about the seller's duties to the firm. The number one duty that the seller owes the firm, well, a couple things that they owe us. Seller agrees to cooperate with firm in marketing the sale of the property, including but not limited to providing the firm in a timely manner accurate information about the RPODs, the MOG, the lead-based paint if it was built prior to 1978. So the seller has a duty to provide those seller disclosures that we talked about last weekend. Seller's duties are going to make the property available for showings, including working in existing utilities at a reasonable time upon reasonable notice. It's going to be awfully hard, unless you're a cash investor, it's going to be awfully hard for me to sell your house if you don't let any buyers walk in the front door, right? So the seller can't contract with you to sell and then not allow showings. They can't hinder my efforts. And that may be another reason why they want to do an office exclusive or coming soon. Let investors have the opportunity before buyers come in. Again, it's up to the sellers. The seller has a duty to provide the firm as soon as reasonably possible after execution of this agreement, copies of the following documents: any restrictive covenants that affect the property, bylaws, articles of incorporation, rules and regulations, and other governing documents of the owners association or the subdivision, owners association statement of account, master insurance policy showing coverage provided and deductible amount, current financial statement and the budget of the owners association, parking restrictions, information, architectural guidelines, title insurance policy, attorney's opinions on title survey, covenants, deeds, notes, anything related, easements related to the property. Seller authorizes any attorney presently or previously representing the seller to release and disclose any title insurance policy and such attorney's filed a firm. The property's title insurer, its agent to release and disclose all materials the property's titles insure. The owners associations, copies of documents. Seller acknowledges and understands that the firm is under no obligation to acquire any of this information to verify the accuracy of such any information that may be provided to the firm. Seller has an obligation to immediately refer the firm to all inquiries or offers it may receive about the property, showing the property only by appointment, or conducting all negotiations through the firm. So basically what that's saying is the seller doesn't retain the right to sell it without you. If the seller learns of an interested buyer, they need to direct them to you. That's why they hired you. So what if the seller goes to work and they're in the break room and they tell their coworker, yeah, we just listed our house this weekend. And their coworker says, oh my God, I've always wanted to live in that neighborhood. Let me make an offer. The seller is required to say, you need to call my agent. Okay, they have to direct everything through us. Let us do our job. Seller has to execute and deliver at settlement a general warranty deed conveying fee simple marketable title to the property, including legal access to public right-of-way, free of all encumbrances except ad valorem taxes for the current year, utility easements, rights of way, unviolated restrictive covenants, and those encumbrances that the buyer agrees to assume in the sales contract. That's their biggest duty right there, right? Convey that fee simple marketable title, general warranty deed. If they can't do it, they're in breach. So let's find this out ahead of time. Seller represents that the seller has the right to convey the property and that there are currently no circumstances that would prohibit them from conveying fee simple marketable title as set forth. We're told to put NA if not applicable. So if we put anything in here, if nothing else, put NA. If any sale of the property is a short sale, consider using the short sale addendum. We'll look at that one after lunch. Seller is to provide the firm in a timely manner any information necessary, including information omitted above, to enable firm to prepare an estimate of seller's net proceeds at settlement. Seller acknowledges and understands that any such estimate is an approximation only, and that seller should verify the accuracy of the calculations. So one thing I like about that seller net worksheet we looked at is you can get 3 different scenarios. So you're not given a definite, it's an estimated net worksheet. The name tells us that, but we can give them 3 different, if you get an offer in at asking price, more than asking price, under asking price. So you could give them a couple different scenarios. If required by this general statute, timely designating a lien agent and providing firm as soon as possible a copy of the appointment of the lien agent. So that's if there's major renovations underway. They say a lien agent is required if the project is $30,000 or more. That's what that general statute's referring to. Home inspections, pre-listing home inspections are gaining in popularity. Some sellers are choosing to have a pre-listing home inspection. First off, this takes the surprise out of the buyers, right? If they, if we can identify any major issues before the buyer asks for repairs, the seller is still not obligated to do any repairs, but at least if they're doing this pre-home inspection, they can still choose if they want to fix anything prior to listing. Sellers advised to obtain a home inspection for the purpose of evaluating the condition of the property in order to enhance its marketability and to reduce concerns of prospective buyers. Seller either agrees or does not agree to obtain and pay for a home inspection within X amount of days of execution of this agreement. Pre-listing inspections aren't as in-depth and not as expensive as what the buyer would get. We're just trying to get the home inspector to do a quick once over, point out anything major, again, so we can either address it now before a buyer shows up or know how we're going to respond when a buyer addresses it, right? Just kind of giving us a leg up here. Anybody have experience with pre-listing home inspections yet? I'm hearing about these more and more out there. Seller acknowledges receipt of copy of the Q&A on home inspections by the Real Estate Commission's website. So if you don't provide this, then don't check that box. But if you do provide the Q&A on home inspections, you can get that from the Commission's website. They got all their Q&A brochures under publications. Great resource at the Commission. Photographs and other materials. Firm is specifically authorized to use for any purpose whatsoever any and all photographs, drawings, videos, advertising, copy, or other information obtained or provided by the firm pursuant to this agreement, including but not limited to any information concerning the price and terms of the sale of the property, the description of the property, and the length of time of the property is on the market. When I show up to your house to take pictures for the listing, those pictures are my property. I understand those pictures may be of your house, but they're my pictures, they're my property. If you list a home after another firm is listed, let's say it expires today, and you're the firm that shows up to list it tomorrow, take your own pictures. Don't take somebody else's work. Don't go into MLS and use somebody else's pictures. They're not going to like that. I had a seller once. They had to fire a firm. They weren't happy. They hired me. They hired me in like the dead of winter. The pool was closed. Spring rolled around. They wanted pictures of the pool. And the seller said, can't we just use the pictures from the previous listing? No, we can't do that. I can't. You're not allowed to copyright and take somebody else's work. I said, tell me when the pool's open and I'll swing by there and take some pictures. So don't use somebody else's work without their permission. Let's see. Materials, both before and after the sale, or in the event there is not a sale after this agreement is expired. Sellers shall not have or acquire any rights to use the materials created by, on behalf, or at the direction of the firm or their agents during the term of this agreement without the firm's consent. If the seller provides any materials to the firms, the seller represents that the seller owns the materials or otherwise has legal right to provide the seller materials to the firm. Seller grants to firm in any listing service in which the firm or its agents participate a non-exclusive perpetual license of the materials, including the rights to display, reproduce, distribute, or make derivative works from the seller materials. Seller agrees to indemnify and hold the firm harmless from any and all claims resulting from the use of the materials. So again, if my former seller had just sent me pictures on her own, I would hope that she understood that that meant that they were her pictures to share. They weren't pictures of the other firm. So sometimes we have to ask some questions. Verify that they're the seller's material. Verify that they're the seller's product before you use somebody else's work. Comments on that? Questions? Additional terms and conditions, anything that the parties, the firm and the seller agree to that aren't mentioned in here. This is pretty much open-ended. Whatever the parties agree to that's not addressed in the listing agreement. I have seen one example, I have seen this used. Let's say I do a CMA. And I do the CMA and I come up with a probable sales price of $250,000 to $265,000. So I suggest, this is our probable sales price. So I suggest that we list it for what? 272. I'm just throwing a number out there, right? Probable sales price, CMA. I'm going to suggest that we put it on the market for a little bit more than the CMA, give us some wiggle room for negotiations. I'm not going to suggest 300,000, even though in this market, I very well could get them that. I don't want to be too much over probable sales price. But let's say I present this and I say, let's put it on the market for 272 and see what happens. And the seller says, can't we do 300? Have you guys encountered that yet? They look at your numbers, they look at your facts, and they say, yeah, but can't we do 300? Well, maybe I can sell your home for 300, maybe I can't. So one place, as an example, that we could use this additional provisions, I say, fine. We'll list it at 300,000 for 1 week. If after 1 week we don't have an offer, we're dropping it to what? 275, right? So we can put in here, if we come to that agreement, we're going to list it 300 for 1 week. And then after that, then we're going to drop it. That's one example of how we could use this additional terms. If we agree to something like that, if I don't have an offer at 300, I may not even have a showing. If I can't get anybody in the front door, we're only going to do this for a week. After that, we're going to drop the price. Just as an example. Anybody have experience using this field for another example? Pretty much whatever we agree to. Dual agency, we're going to come back to this. I got a section dedicated to dual agency, so we'll talk about dual agency tomorrow. So let's come back to this and we'll address this later. Oh, bless you. It's allergy season. So we'll come back to this. I think this will help a little bit more once we discuss dual agency. For right now, what I want you guys to see is that the seller has a place. They either authorize the firm to act as a dual agent, or they want exclusive representation and do not authorize the firm to act as a dual agent. The seller needs to initial one or the other. They either allow dual agency or they don't. Again, we'll come back to this tomorrow. If they say yes to dual, then we have the option, if your firm allows it, to offer designated dual agency. In order to have a yes to designated, I first have to have a yes to dual. I can't do designated without dual. So we'll talk about that tomorrow. Mediation. If either party breaches, this just says we're going to try to hash it out in mediation instead of trying to go to court or anything. See if we can't address it outside of court. And then we got a wire fraud warning. I'll let you guys read this. Wire fraud's gotten really big, really fast in real estate. Think about all the money that changes hands involved in real estate with the purchase price of a home. And we have a wire fraud warning to the sellers in the listing agreement. We will see a wire fraud warning to the buyers in the buyer's agency agreement. And then we see a wire fraud warning to both buyer and seller in our offer to purchase and contract. Guys, bottom line, the best thing we can do to protect our clients is look them in the eyeball and tell them that you will never email wire transfer instructions. And then don't. If they ever get an email from you with wire transfer instructions, you've been hacked. Okay, so if you have that policy to never email them, in order for sellers and buyers to get wire transfer, get or give wire transfer instructions, they need to go old school, pick up the phone and call the attorney, call the paralegal, and get those directions over the phone. And the number that they're calling needs to be a number that they independently obtained. That phone number does not come from an email that they got, because the hackers could send an email, say, call this number. And now when they pick up the phone and call that number, they're calling the hackers, not the attorney. You guys with me? So have them go to Google, look the phone number up and call that number. Most firms today, I know mine does, and yours probably do as well, have a policy that said, I'm basically going to lose my position with that firm if I email wire transfer instructions. Most firms have something in place that say, if you do this, we're going to let you go. So I think that's the best thing we can do to protect our clients. Other things we can do, stop using password 1234 for your password. That's not a good password. Capital P password is not a good one, right? 12345. Yeah, don't use that over and over and over again. Turn your two-step verification on. You know, for example, I have two-step verification on my Gmail. So if I log on to a new device, not only do I need my password, but I also am going to get a text on my phone to put that code in. So it's an extra step. It's such a pain in the butt, because usually when I do that, I don't have my phone sitting with me, so I have to get up and go get it, you know, but it's worth it to protect your client's information. Careful about what you do when you're working on a public Wi-Fi as well. If you go to Starbucks to work this afternoon and you hook up to Starbucks public Wi-Fi, who can access that? The public. So if you insist on working at Starbucks, that's fine, but consider hooking up to your mobile hotspot on your phone and not the public Wi-Fi. I haven't heard of a lawsuit hit in North Carolina yet, but other states are facing this. And I'm telling you guys, when buyers and sellers lose money at the closing table due to wire fraud, they're going after everybody involved. The attorney, me, you, the other agent, everybody that was involved in that, they're trying to get their money back. So just do what you can to protect your clients, protect yourselves, have conversations with them. Comments on that? You guys experienced this yet? I say yet, no, and you will. Have you talked to your sellers and buyers about this? Good. Some firms have like a wire fraud in-house form that they can use. Again, help us have this conversation. I went to a wire fraud seminar a couple years ago. We were still in person, so it was pre-2020. It was down in Raleigh. And the FBI was one of the speakers, and the FBI stood in front of us and said, hackers are always 2 steps ahead of us. So about the time the FBI is figuring it out, they've moved on to the next thing. People don't run around and wear their I'm a hacker t-shirt, right? So you don't know who's a hacker and who's not. So Donna, the attorney contacts your client directly. That's great. That's great. The paralegal. Yep. And some attorneys are still emailing it to me and saying, transfer this to your buyers or forward this to your buyers. No, my buyers are going to call you to get you directly, or the attorney in your case is reaching out to them. That's good. I'm glad. I think it took attorneys longer to get on this than it did me and you, because we're being instructed not to do it, but attorneys were doing it, you know. By the way, attorneys were invited to the wire fraud seminar that I was at as well. So it's a conglomeration of brokers, attorneys. Entire agreement. Basically what this is saying is we're not going to piecemeal it. Our exclusive right to sell listing agreement, everything together is one agreement. We're not going to say, okay, this applies and that doesn't apply, right? We're not going to say I'm going to take A, B, and C, not D, E, and F. The entire agreement constitutes everything together. Seller and firm acknowledge receipt of a signed copy. We need to make sure that our seller gets a copy once signed. How many days do we have to deliver a copy to our seller once it's been signed? 3 days. We deliver all instruments within 3 days of execution. So once you get your listing agreement signed, then as we mentioned earlier, I got a place for 2 sellers to sign. So you can put the seller's name, have them sign and date, and then their contact information. If you have more than 2 sellers, use the additional signatures addendum. So you use as many signature fields as you can to get everybody to sign. Here's where we would complete if the seller is an entity seller. We list the name of the corporation. And then there is one person that is allowed to sign on behalf of the firm of the corporation. But the corporation's name, the company's name is who goes in this field. You guys with me? So ABC Company is the entity seller, signed by Julie Campbell or whomever has the authority to sign for on behalf of the company. And then we have the firm. The relationship is between the seller, the client, and the firm. So we're going to put the firm's name. Your firm has a license number and the office address, and it's signed by the individual the individual agent with their license number. This is part of my authority that I have with the firm. The relationship is between the seller and the firm, but I have the authority to sign the listing agreement on behalf of my firm. And then my contact information. Again, changes coming in July. I don't know exactly what, but if you're affiliated, your BIC, pay attention to your email. Your BIC will probably offer training. NCAR does a nice job when our forms update. They actually send us a markup that tells us what's strike through, what's added. So we're not expected to do a side-by-side comparison. So I'm appreciative of NCAR of getting us that information. So just make sure you're paying attention in July. When they update the forms, they give us about 60 to 90 days to start implementing the new forms. So if they roll out on July 1st, take a big deep breath. You don't have to have your hands on the new forms ready yet, but know that they'll be coming out in the next 60, 90 days. I don't remember offhand which one it is, but. Questions or comments on our exclusive right to sell listing agreement? Good stuff. The other thing I want to point out, let's see, under forms, you have the exclusive right to sell listing agreement again. So you got it both under forms and you got it under the section 2 material. We also have the guidelines for completing. So if you're, are you guys there? Have you guys? Okay. I just froze for a second on my end. So I just want to make sure you still. So this is provided by NCAR. If you're not affiliated with a firm yet, you're welcome to grab this and download it if you want to review it. If you are affiliated with a firm, then you have this. And again, it just pretty much just walks through the provisions that we did to make sure that we're properly completing these forms. So these guidelines to complete are here to assist us. We also have an exclusive right to sell listing agreement when you're selling vacant land. So if you're listing a property that doesn't have a structure on it, we have a separate exclusive right to sell. I'll let you guys look at that. And that too also comes with the guidelines to complete. So again, when in doubt, find out. You guys have the resources. Make sure you're utilizing them. Again, thank you, Forms Committee, for providing us with this information. We mentioned the internet advertising addendum. If your seller doesn't want their information on the internet, then we need to use this form with them, it adds to the exclusive right to sell listing agreement. The note tells us that this form should be used only if a seller is elected to limit or prohibit internet advertising of their property. So if they say, I don't want this on Zillow, for example, then we need to use this form. And it goes through, again, I'll let you go through this if anybody encounter this yet. This was a big deal. I think, I mean, obviously this form came out whenever it was created. I remember when it came out. I think that's when internet advertising was really starting to gain popularity. So not all sellers want to see their information splattered all over the internet. So again, we just need to, you guys encounter this yet? No, I think the internet's becoming more of a acceptable practice than what it was 20, 40 years ago. Y'all believe the 80s was okay? Anyway, we're not going to go there. The 80s wasn't just yesterday anymore, was it? The other one I want to point out really quick. Agency agreement renewal and or amendment. So we're going to use this if, for example, we have a listing agreement, Form 101, and let's say that it expires today. So our listing agreement says, what year is it, Julie? Our listing agreement says that it expires today, but we've chosen to extend the listing. Maybe we're going to extend it for 2 more months or 4 more months, whatever you guys want to. So we could go in and edit the listing agreement, edit that date. But as you guys can see on a lot of our forms, I don't have a lot of room to put in much more information, right? It's not like I have big information here in the margins or anything. Oh, thank you, honey. I just got fresh coffee. So I don't have information here in the margin or anything to put in. So some firms will require this instead of marking up the listing agreement. But you see, we can put in the property address, and then we have the agreement to renew or amend. So we can either renew it and extend it to, and we put in the new expiration date. If we want to do a price change, maybe we're going to do a price drop, for example, we can use that form to do this, or other amendments. Maybe the seller has first said no to a pre-listing home inspection, but now they decided they want a home inspection. Maybe they previously said no to the home warranty, and now they're deciding that they want to add a home warranty. So again, we have options. We can mark up and edit the actual listing agreement, or we could use this form, and that way we have a paper trail. That's one big benefit of dot loop. I know you guys may not agree with me. You can't delete anything in dot loop, can you? And that's designed that way for a reason. It's helped to keep us honest. So nothing ever goes away. So you always have paperwork. You always have that information. And then there's a place for everybody to sign, client, firm, etc. Questions on this one? And this isn't just the listing agreement, by the way. Let's make sure we see this. This could be the listing agreement. This could be if we're extending our exclusive buyer agency agreement, tenant agreement, auction sales. So this allows us to renew or amend any of our agency agreements. This is Form 710 if you're the numbers person. Sometimes knowing the numbers is easier to find the form. There are like 100 forms in NCAR, hundreds of forms in NCAR. Just to point out real quick, wire fraud notification addendum. You might want to use this with your buyer or seller. As I mentioned, some firms have created their own or haven't had an attorney create their own form as well. So again, helping to protect the consumer. We'll talk about short sales when we get back from lunch. Questions? So with the listing agreement, everything has to be filled out prior to having the seller sign it. As we said, I absolutely cannot get a signature until we've had the listing price. We have got to have an agreement on the listing price before we can sign the listing agreement. That's where we're doing our CMAs. Are you guys familiar with, there's another way to help us with pricing. It's called absorption rate pricing. Are you guys familiar with this yet? Absorption rate pricing is another way to help us. What absorption rate pricing looks at is time. So the question always comes up, how long should our listing agreements be for? Well, if we're doing our absorption rate pricing, it tells us how long is it taking the average home in this area to sell. So if the average time to sell, again, not in this market, but in the average time to sell is 2 weeks, you would want to, or let's just say 3 months. I'm just making stuff up. Your average time to sell is 3 months. You wouldn't want to sign a listing agreement for 2 months, would you? Because your absorption rate pricing tells you that you need about 3. So get with your firms, Google this. I think this is becoming more another way to look at and to do in addition to CMAs. So CMAs help us determine probable sales price. Absorption rate pricing helps us determine time. In this market, you might feel comfortable signing a listing agreement for a month, but I'm promising you, we're not going to be in this market forever. There's going to be a time where houses sit for 4, 5, 6 months longer. So just make sure you have a listing agreement, a reasonable time on your listing agreement. We've said this before. This is kind of a reminder. Any information entered into the MLS has to be accurate. The listing agent is responsible for the information, period. If you have somebody else putting in your own listings, you are responsible for it. If your firm enters listings, you are responsible for it. The listing agent is the one that's responsible. They're the one that's going to be held accountable for the information, the accuracy of the information. And again, as we have said before, disclaimers are not going to protect us. So I can't say, I mean, I can say buyer to verify, but it doesn't negate my duties to discover and disclose material facts. So just saying buyer verifying isn't an out for me. Disclaimers are not going to protect us. For the most part, buyer's agents should be able to rely on the information provided in the MLS. But as a buyer's agent, if you or your buyer have a flag go up, then we need to investigate. We need to ask questions. We need to make sure that we get the buyer that information. So if we don't have a little red flag go up, we should be able to rely on it, but we're always paying attention to those red flags. When you market the property, we have to practice that reasonable skill, care, and diligence. That's our R in old car. That's part of what our listing agreement says. This is why we have the conversations that we do with sellers. This is why the listing agreement is set up that way. Make sure we're getting the appropriate information. So practice reasonable skill, care, and diligence. We have to have the owner's consent to put a for sale sign, for rent sign, display their market, their property is for sale or for rent. Guys, when it comes to listing agreements and property management agreements, when I'm working for an owner, I cannot conduct a single service without first having a signed agency agreement. When I'm working with an owner, agency agreements have to be signed from the onset. So we have their consent to market their property. We have to comply with laws and rules on sign placement. Chastity earlier brought up HOA restrictions. Some HOAs won't let you put a sign in the yard. So we have to comply with those. Back in the day when we were doing open houses, when we had inventory and we were allowed to do open houses. I know, for example, Forsyth County says our open house directional signs can't go out. I think it's like Friday before noon, and you got to take them down when you're done on Sunday. I think we get like Sunday to 5. So you can't put your directional sign out, you know, on Wednesday and then leave it there forever and ever. So know your local laws and rules when it comes to placing signs, advertising. It's hard to sell a house during election time, isn't it? Because everybody's got a sign in their yard now. How do you know it's a for sale sign or a vote for so-and-so sign? So there's a meme floating around that time, election time, that says I accidentally voted for a real estate agent. Blind ads. Blind ads are not allowed. A blind ad is missing what? What doesn't a blind ad have? That's right. That's right. Dawn, I saw your mouth move too. Yep. A blind ad doesn't list your firm. Once again, I ask you, whose listing is it? It's the firm's. So make sure, and you can't have like, for example, Chastity couldn't have chastity@bhhs.com and think that she's listing the firm. So if that's her email address, chastity@bhhs, I don't know if it is or not, but let's just pretend, Donna at, patrobertsonrealty.com, right? Just because your email address may state the firm doesn't mean you're advertising the firm. I see this a lot on social media, a lot. Social media is advertising, yes? So if you're advertising social media, we could spend 3 days debating about whether or not you should have a personal Facebook or a business Facebook. We're not going to get into that debate. That's something for you to consider, for you to take into account. But if you choose to go the personal Facebook route, just make sure your firm is mentioned in the ad. Everybody good with that? I see this a lot every day. I'm getting her to scroll through Facebook on lunch, and I promise you I'll see it while I'm sitting here at lunch. Does that make it right? No, just because everybody else is doing it. We need to talk about, and we will when we get back from lunch, we'll get started on it right now. Some truth in lending requirements. There's advertising requirements that come with truth in lending. So we'll talk about that more in just a second. That's what that little asterisk mean. So I got a little bit more. When we come back from lunch, we'll talk about our fair housing and various advertising restrictions. We've kind of touched on this already with Tried MLS's new software, helping to find words that could be a potential violation. Again, if I put white cabinets in MLS in public remarks, it's not telling me I can't use it. It's just giving me a warning to make sure that I'm using the term the term white properly. Make sure you're using it to describe a feature of the property and not the people. That's right, it flags it. It says warning, and before I submit, it asks me to review it to make sure I'm using it. So we'll talk about fair housing advertising. And then internet advertising. Again, internet ads are ads. So no blind ads on social media, no blind ads on the internet. And make sure that you want to comply with your firm and fair housing anytime you advertise. Internet advertising is tricky. Y'all know what happens once you hit submit. It is gone, and it's really hard to get it back once it's out there, right? So it doesn't hurt to have another set of eyes on it before you release it. It may be something for you to think about. So let's talk real quick about this complying with truth in lending. First off, the Truth in Lending Act is what we often refer to as TILA. TILA is the T in TRID. So you got TILA, RESPA, integrated disclosure. We're not going to talk about RESPA or TRID for that matter in this class. We reserve that for 302. So if you haven't taken 302 yet, you can learn more about RESPA and TRID. The reason we talk about TILA in this class is because of the advertising, making sure that we're properly promoting our listings, marketing our listings. TILA can also be referred to as Regulation Z. I would know that if I were you. Captain Obvious over here. Okay, so Regulation Z is also known as TILA. TILA stands for the Truth in Lending Act. It's the T in TRID. And when it comes to advertising, what TILA means, what TILA stands out, are something known as trigger terms. if any of our advertisements have trigger terms, TILA says, Regulation C says that we have to disclose all the terms of the loan. We'll talk about those in just a second. So specifically trigger terms. The difference in a trigger term is when you specify a number about the loan. So for example, if I'm advertising the down payment, do you guys hear the difference in me saying $1,000 down versus low down payment? $1,000 down versus low down payment. The trigger term was the $1,000 down, right? Because I specified a number. I told you how much your down payment. With the amount of payment, you know, $700 per month. Maybe we got a seller financing and we advertise $700 a month versus easy monthly payments. You guys hear the difference here? A trigger term is when we actually report a number about the loan. Is the purchase price about the loan? No. Are the HOA dues about the loan? No. What about seller pay closing costs? Just because you see a number doesn't mean it's a trigger term. It's got to be a trigger term about the loan. Number of payments, 30-year mortgage versus long-term financing available. Finance charges, interest less than $300 per month versus low financing. TILA applies more to the lender. I'm sorry.
I just have a quick question. So if you put like a number down, like even if you say a low monthly payment of like 700, so as long as you put a number there, that will become a trigger term?
That's right. A trigger term means you've hit a specific number about the loan. That's a whole sentence. I hope you guys hear me saying the whole thing. Specific number about the loan. Okay.
And with that being done, you have to release all the numbers.
That's right.
Right.
And we're getting
And
right,
then
and we're
you-
getting ready to talk about what specifically you have to, if you hit a trigger term. Yep. So we're going there next. Yep. TILA is a lender law, but we need to be aware of this too, because we advertise and market properties, right? So we too have to comply with the trigger terms. So if a trigger term is hit, again, a specific number about the loan, then we have to disclose the amount or percentage of the down payment, the terms of the loan repayment, and the APR. So if the advertising says $700 monthly payment, then we got to disclose this information. That's what TILA says. Again, it's a lender law, but are we advertising homes for sale? Are we marketing? Are we promoting? Yeah. So we need to be aware of these as well. What if you're doing an agent luncheon, a broker luncheon, and you've called your lender buddy and asked your lender buddy to go in on that broker luncheon with you? Your lender buddy's probably going to say, yeah, because it's a great opportunity for them to meet other agents, right? So they're going to say, yeah, I'll go in on that broker luncheon with you. And then they say, I'll tell you what, I'll do the flyer. So they produce the flyer for you to distribute, and they hit on a trigger term, and your name, your contact information, your picture is also on that flyer. Could you go down too? Yep. So this is why we need to be aware. Proof the flyer before the lender sends it out. As we said, if any specific number is advertised, then all that information. If you hit a trigger term, then you got to disclose all of it. We can advertise, you know, how much the house is, list or lease price, seller pay closing costs, HOA dues. That's not information about the loan.
So the seller pays $3,000 closing costs. That is not.
That's not
That's
about
not
the loan.
about the loan. Okay. Yeah,
Correct. That's something the seller's offering,
Okay.
right? HOA dues. sales price, lease price. Those are not numbers about the loan. Other questions about TILA, Regulation Z, advertising? Okay. All right, y'all hungry? I'm hungry. So let's break for lunch. So let's see, I got 12:56. We'll come back at 2. I'll log on at 1:55. We need to start right back up at 2 though. So we're awfully close to being done working with sellers. Like I said, this afternoon, we'll switch gears and working with buyers. Before we leave today, we're going to look at the other math formula, the other math that you're going to see on your test tomorrow. So even if I have to skip around a bit, I do want to cover that today, so you guys have time this evening to look at it before the exam tomorrow. Questions, comments? All right, y'all have a good lunch. Be ready to start back up at 2 o'clock. Don't eat too much and get sleepy, okay? Be ready to start back up at 2 o'clock.
Julie, how